Ready.
And Ms. Frau, thank you. And for the defense, lead counsel, are you ready?
Yes, Your Honor, we are ready.
And Mr., is it pronounced Kunath?
Kunath, sir.
Kunath, thank you. All right. Traditionally, the sides have provided the scoring panelists and the court with a trial roster. Apparently that has been posted in the chat section. I find it not really necessary to have that document, quite frankly, although it is available to all of us on the both the court and the jury. Given the nature of the electronic scoring sheet, it is very apparent who is talking at all times. I'm going to be asking you as a matter of procedure, however, that whenever you take a witness, do an opening, do a closing, when you first address the court, please state your name. And we're getting some feedback from the Arapahoe County.
The first time.
Please put your
ousted from the A-team, the place where she was the center of attention. So she encouraged her best friend Taylor.
We're getting the Arapahoe County Judge White. If you could mute your microphone there, we have you, and we're getting some interference. So there we go. We just had the microphone muted. So please do announce yourself. You don't have to do it every time you speak, just the first time you speak on any witness or in opening or closing. That way the scoring panelists will know who's speaking, and your name will appear, of course, lit up on the screen. I need to confirm with the participants and also with those of you who are hopefully joining us on YouTube that you may not record this proceeding, and please take that into account. No recording unless there is some prior agreement. The Colorado Bar Association may take screenshots, and that is implicit in your agreement to participate in this matter, and those may be published at the discretion of the Bar Association. You are aware, of course, all of the attorneys and participants, that no recesses will be allowed except for health emergencies. Please don't, if something happens health-wise, please let us know. Also, if you have connection problems, please let us know. If you cannot hear, if you cannot see, wave your hands if you still have video, and we will stop, and time will stop until for a reasonable time to get you reconnected or perhaps even connected by telephone. But hopefully that won't happen. But if it does, make sure we see you or hear from you. If you have no video and no audio, text one of the other participants so that they can tell us that you have lost connection. I'm going to ask each of our jurors to introduce themselves, give them a brief, give the participants a brief description of who you are, what you do, and also, finally, whether you have any conflicts with any of the participants in this matter. Mr. Henderson, if you'd go first.
Thank you, Your Honor. No conflicts. My name is Tom Henderson. I'm a civil trial lawyer at the Berg Simpson Law Firm and in Englewood, and also happen to be the current president of the Arapahoe County Bar Association. Thank you.
Thank you. And Mr. Bird.
Thank you, Your Honor. I have no issues here. My name is Nathan Bird. I'm in my last semester at Denver Law, and I'm very happy to be here again.
Well, congratulations. And last but certainly not least, Mr. Rich.
My name is Greg Rich. Half of you saw me yesterday. I'm a civil defense lawyer at the firm of Coombe, Curry, Rich, and Jarvis. We regularly have cases against Mr. Henderson's firm. I'm a former president of the Colorado Defense Lawyers Association, and known Judge Wheeler for a number of years through an organization called the Inns of Court, where lawyers, judges, and law students all get together once a month to dine, drink, and mentor. We're going to miss him in the group.
Thank you, and a good plug for the Doyle Inn of Court. Please remember that any disputes that arise, whether they are within the trial or outside the trial, must be raised either by the participants inside the court or by coaches outside the court in accordance with the rules. Time requirements are strictly held. And of course, you are not cut off, but you may be graded down if you run over your allotted time. And we do have our timekeepers. Does the prosecution have a request both for opening, closing as one type of time and witness time as another type of time on how you would like to be notified by the timekeepers, in what increments? For Ms. Frau, for as lead prosecution attorney, do you have any requests for the timekeepers?
I think our timekeepers know the increments. It goes 4, 3, 2, 1 for opening and closing, and on a similar increment, but starting at 20 and then going to 15, 10 on witness examination.
Okay. And Mr. Kunith, do you have any requests for the defense as lead counsel?
No, Your Honor. In terms of the timekeepers, they understand in terms of for direct and cross-examination to go in 5-minute intervals, and then for each minute when it's less than 5 minutes, and for each minute during opening and closing statements, Your Honor.
And I assume for both sides that will be posted in the chat box.
Yes, Your Honor.
Yes, Your
Good.
Honor.
Okay, now as to other procedural matters, any of you doing presentation, whether it is opening, closing, direct, or cross, please feel free, if you wish, to remain seated while you are giving your presentation. You may stand, no problem, but you also may remain seated rather than just up and down all the time. Please feel free to stay seated if you wish. You will not be graded down for doing so. That is the standard now, actually, in virtual proceedings before the court in all matters. So don't feel that you have to, but if you are compelled, go right ahead and stand up if you wish. As far as evidence presentation, for each side, for the prosecution team T, are you assuming that you will have co-counsel be sharing documents once they are admitted? Is that something you are prepared to do?
Your Honor, I was going to ask that we share our screens to present evidence, but until it is entered, when we're sharing our screens, that evidence should only be regarded as being shown to opposing counsel and the witness. But then once it's entered, you know, yourself and the juror members can see it.
Okay, so you will or will not share during the admission process on the screen. You will share it, but it is not to be considered by the jury because it is not yet admitted. And that is the way we did it in one of the trials yesterday. Worked just fine if because the jury is not judging this contest on the evidence. They're judging it on your presentation. So it really doesn't matter if they see it. If I don't admit it, it doesn't matter if they have already seen it. I will tell them to disregard it. Is that acceptable for the defense as well?
Yes, Your Honor. We would like the, in terms of the defense counsel, in terms of the presentation of the exhibits, whether marked and admitted to reflect the same as the prosecution counsel.
Good enough. So we will just see the evidence as a shared screen. Just make sure you have a co-counsel designated to do that so that there is not any unnecessary delay in posting that on the share screen.
Thank you, Your Honor.
Okay, let me see here. I'm going to ask first Ms. Frau as lead counsel, if you would introduce yourself and then request each of your attorneys to introduce themselves.
All right. My name is Virginia Frau. I am a prosecution attorney today, and I will be conducting the direct examination of Detective Jordan Markowitz and the cross-examination of the defendant Avery Becker. My co-counsel may proceed.
My name is Olivia Fendrick. I am a prosecution attorney. I'll be conducting the direct examination of Alex Cifuentes, the cross-examination of Professor Blake Van Owen, and I will also be giving the opening statement.
Thank you. And finally,
good morning. My name is Gwen Fitzsimmons. I will be providing the direct examination of Kyle Kuzak, the cross-examination of Taylor Perkins, and doing the closing statement. And may our witnesses have permission to introduce themselves?
yes, if we could have your first witness introduce him or herself, yes, with both your real name and your character name.
My name is Sloan Smith, and I will be playing Jordan Markowitz.
And Ms. Smith, you need to speak up just a little bit, just for, because you're a little bit faint there, but not too bad. And you'll be playing whom?
I will be playing Jordan Markowitz.
All right, and second witness?
My name is Mallory Coughlin, and I'll be playing Kyle Kuzak.
And third witness?
Good morning. I'm Olga Serbala, and today I'll be playing Alex Cifuentes.
Thank you very much. And on the defense side, Mr. Kunith, if you could introduce yourself and ask your co-counsel to introduce themselves.
Yes, Your Honor. Good morning, everyone. My name is Edmond Kunith, and I will be directing Blake Van Owen as well as crossing Alex Cifuentes. I would now like to direct it towards my co-counsel.
Hello, my name is Braden Rowe. I am going to be directing Avery Becker, crossing Kyle Kuzak, and conducting the closing statement.
Thank you. And finally?
Good morning. I'm Trisha Bolani, and I will be directing Taylor Perkins, crossing Detective Jordan Markowitz, and conducting the opening statement.
Thank you. And for your first witness on the defense side.
Good morning, Your Honor. I am Ananya Shrestha, and I will be playing the defendant, Avery Becker.
And your last name is spelled, or is pronounced, give me a moment. Shrestha?
Yes, correct.
Threshta. I'm going to have to work on that one. Threshta. That's a lot of consonants. So if I mispronounce, please correct me.
Okay.
Give me just a moment. And I'm sorry, you will be Ms. Becker?
Correct.
And next witness for the defense.
Good morning. I'll be Lily McGee, and I'm playing Taylor Perkins.
And finally?
Hello, my name is Dylan Zook, and I will be playing Blake Van Owen.
Thank you very much. And if I could have the timekeepers introduce themselves, please, for each side. First, the prosecution.
Good morning, Your Honor. I'm Lane Gray, and I'm going to be a timekeeper today.
And for the defense? Do we have two timekeepers for the prosecution?
That's correct, Your Honor. I'm Harvey, and I'll be the other timekeeper.
Okay. And do we have a timekeeper for the defense?
Yes, Your Honor. My name is Natalie McLean, and I will be a timekeeper.
Great. Do we have a second for the defense?
No, Your Honor.
Great. Thank you very much. Okay. I'm now going to swear everyone in three groups. the attorneys, the witnesses, and then the scoring panelists. All attorneys, all 6 of you, if you'd please raise your right hand. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Thank you. And for all 6 witnesses, if you'd please raise your right hands. Do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements and that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your
Yes,
Honor.
Your Honor.
Yes, Your Honor.
And for the scoring panelists, if you would, the 3 of you have raised your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
And although not indicated here, I'd ask the timekeepers to raise their hands. Do you promise that you will faithfully keep time in accordance with the rules and the requests of the participants? Thank you very much. Okay, before we move into the opening statements, does the prosecution have any issues they would like to raise, Ms. Frau?
None here, Your Honor.
Okay, and Mr. Kunith, on the defense side, any preliminary issues?
Yes, Your Honor. May my co-counsel publish a copy of the stipulated facts upon which both sides have agreed to?
You may, you can put it in the facts section. We do all have access to that.
Thank you, Your Honor, as well as, of course, throughout the trial, including opening and closing arguments, as well as examinations for both the prosecution and defense counsels to remain seated due to the limitations that we're currently at, as well as for the defendant to be on camera when asked for identifying purposes, Your Honor.
Defendant may be placed on camera when requested by the prosecution, yes, for identification. And as I indicated, you may remain seated or stand at your discretion.
Thank you, Your Honor. I have nothing further.
Okay, we will now move into opening statements. And I forgot who is going to be giving the opening statement for the prosecution.
That would be me, Your Honor.
And Ms. Fendrick, if we could have opening. Thank you.
Thank you. The death of a beloved coach, betrayal, a scandal that shocked a school to its core. Today, we will see the results of a free democratic trial. But in such a society, we must also maintain the right to safety and justice. Your Honor, members of the jury, opposing counsel, my name is Olivia Fendrick, representing the people of the state of Colorado in this case. The defendant has been accused of attempting to take revenge on their mock trial coach by way of burglary and inadvertently murder. This case has been brought under the Colorado law for murder in the first degree, in which someone other than a co-conspirator dies during a commission of burglary, and the Colorado law for burglary in the second degree, in which a person knowingly enters a dwelling unlawfully with the intent to commit a crime against another person or property. The facts of this case are clear. After being told off for inappropriate behavior at a regional mock trial tournament, the defendant vandalized the car of victim Mackenzie Brackman. When this event led to their expulsion from the team, and after unsuccessful attempts to rejoin, the defendant decided to burgle the home of Mackenzie Brackman with the intent to trash it and get revenge for actions that the defendant deemed unfair. On March 6th, after entering the Brackman household, the defendant was caught off guard by the presence of their former coach. Surprised, they did exactly what they do best: act irrationally. They stabbed the victim in the shoulder and fled the crime scene. There are certain facts in this case that are not in dispute. They are that the signatures on the witness statements are authentic, chain of custody for evidence is not in dispute, stipulations cannot be challenged or otherwise contradicted, that Exhibit 22's audio recording is an accurate copy from the court proceedings against Jonathan Rollins, and that the death of Mackenzie Brackman did in fact occur. Both parties have agreed to these stipulated facts. Now, under Colorado law, there are several elements that must be proven for the defendant to be convicted. First, my colleagues and I must prove that the defendant committed the murder. Then we must prove that the crime took place in the state of Colorado at or about the date and place charged. Next, we must prove that the defendant acted alone or with one or more persons. We must then prove that the defendant committed or attempted to commit second-degree burglary. And finally, we must prove that during the course of or in furtherance of the crime of second-degree burglary, the death of a person not participating occurred. The prosecution will call 3 witnesses to the stand. We will call a homicide detective, Detective Jordan Markowitz, who will testify that the defendant is in fact guilty after trying to vandalize Mackenzie Brackman's house and will do so by tracing cell phones. Kyle Kuzak will be called and will explain that this crime was planned by the intruder and how our victim was fatally injured by them after Mr. Brackman ensued a fight out of defense. The defendant's close friend from the mock trial team, Alex Cifuentes, will testify that the accused did in fact have violent intentions towards Mr. Brackman due to their problematic relationship, and the defendant's anger and unpredictable tendencies demonstrated in mock trial are what led to Mackenzie Brackman's murder and the very reason why this trial is being held today. The defense will claim that there is not enough evidence to prove the accused guilty of Mackenzie Brackman's murder, but the 3 witnesses called to the stand today will state that the intruder and murderer had very clear intentions and planned this crime well in advance, which can be proven through multiple pieces of evidence and 2 expert witnesses. Through a former teammate of Avery's, we'll learn about the anger the defendant held and their serious pranks, so-called jokes that were taken too far. We will learn of the defendant's violent nature towards their coach, all signs indicating that they held no respect for Mr. Brackman whatsoever, and how they sought revenge for every criticism Mr. Brackman made through their bad attendance record, vandalism, and ultimately Mr. Brackman's murder. In order to be convicted, the defendant must be proven guilty beyond a reasonable doubt, the burden of proof being on we, the prosecution, to prove to the jury's satisfaction the guilt of the defendant. This means that the burden of proof will only be met once the jury concludes that the accused is undoubtedly guilty of the charges presented. Colorado's burglary and homicide laws exist to protect our citizens and serve justice to the unfortunate victims of such atrocities. If a guilty person is allowed to walk free, not only will the life of the hapless victim remain unavenged, but the assailant could very well kill again. It is our civil duty to see that justice is found here in this courtroom today. I ask that you keep your mind open until all arguments have been made, evidence has been entered, and witnesses have testified. For these reasons, based on the evidence that will be presented in this trial today, there is no reason why a verdict other than guilty should be returned. Thank you.
Thank you. And after each witness or after each presentation, I routinely pause for just a second to let the scoring jurors do their job. It's not a very long time, but just gives them time to collect their thoughts and do their job. We'll now have opening statement from the defense. And Ms. Balani, please proceed.
Hello, I'm Trisha Balani, and I will be representing Avery Becker, the defendant in this case. Let me take you back to the golden days of childhood, when we'd pass our days by solving puzzles, and the worst frustration in our 6-year-old self's eyes was finding multiple missing pieces. We'd look back at the puzzle and find that the picture is almost unrecognizable without those pieces. Now imagine this. The puzzle's picture is the scene of a murder, and the blood is on your hands. The puzzle presented to you by prosecution is an incomplete one. On March 6, 2020, Mackenzie Brackman was found dead at his residence. According to the prosecution, the defendant, Avery Becker, a teenager with a natural talent and passion for mock trial, is guilty of murdering Brackman. The prosecution is required to prove this case beyond a reasonable doubt, and they will fail to meet that burden. Throughout this trial, the facts and evidence will prove that Becker has been wrongfully accused of murder. We're here to encourage you to take note of all the missing pieces. Imagine you're our client, Avery Becker, a teenager who's still navigating the world, but you have a gift of persuading juries and arguing cases well in court. Unfortunately, Becker was punished for this gift. She often came to mock trial meetings unprepared, which became a source of conflict between her and her coach, Mackenzie Brackman. Eventually, Brackman demoted Becker to the Colorado High School mock trials B team. Naturally, Becker reacted in a foolish but typical teenage manner. Becker wrote on Brackman's car using what she thought was an erasable marker, and as a result, Becker was kicked off the mock trial team entirely. The prosecution will tempt you to believe that this is enough motive for someone to take another's life. The reality is that Becker has shown remorse for her actions and repeatedly tried to apologize to Brackman. Today, you will hear from two supporting witnesses, Taylor Perkins and Blake Van Owen. Taylor Perkins is another member of the mock trial team at Colorado High School and is also Becker's best friend. During the day of the crime, Perkins was with Becker the whole day as they were looking for Becker's phone, which went missing the night before. Though Perkins and Becker went to a variety of places, including the mall and the fry shack, evidence will show that they never strayed from their search and certainly did not travel to Brackman's house. Professor Blake Van Owen is a private investigator and professor. He has previously testified as an expert in crime scene reconstruction, cell tower analysis, and police investigation tactics and practices, including use of force and false arrest. He is a strong advocate for social justice in law enforcement. In this case, Professor Van Owen investigated the inconsistencies with the prosecution's crime scene reconstruction, including issues with scuff marks, stab wounds, and the footage from Brackman's Ring camera system. The presented puzzle is one that is incomplete, thanks to the very police trying to convince you that Becker is guilty and fully capable of committing murder at age 17. The prosecution will try to convince you that this is the full picture. However, you'll consistently observe their missing pieces. Starting with Detective Jordan Markowitz, who has questionable certifications and made assumptions with insufficient cell phone data, as well as from other witnesses, including Kyle Kuzak, a biased officer, and Alex Cifuentes, a member of the Colorado High School mock trial team who is constantly in competition with our client, Avery Becker. Throughout this entire trial, as defendants, we will make it evident that there are numerous missing pieces in the prosecution's puzzle, which will prevent the prosecution from proving that Becker is guilty beyond a reasonable doubt. From a lack of investigation to simple assumptions made based off of insufficient evidence to a clear lack of motive from our client, the jury will see that this investigation was nowhere near thorough enough to convict Avery Becker of murder. The police have attempted to put this puzzle together using an incomplete set of pieces. With this, they have created their own picture, a marred representation of what actually happened. Members of the jury, the power is in your hands. When it comes to a lost life, we can't be satisfied with an incomplete picture of the puzzle. Rather, we must recognize the missing pieces. Today, we're simply asking you to bring justice to Avery Becker and the late Mackenzie Brackman. At the end of this trial, I ask you to submit a verdict that Avery Becker is not guilty. Thank you.
Thank you. And again, we'll pause for a moment as we are pausing for the scorekeepers to catch up. For our examination on each witness, I would ask that obviously the counsel who is either directing or crossing at any particular time, your camera and microphone will of course be on. The witness's camera and microphone will be on. But I also ask the opposing counsel, whether it be prosecution or defense, who is going to be cross-examining or during cross-examine, opposing cross-examination, leave your microphones open, please, so that you can make an objection immediately and without delay. This worked very well yesterday. We did not have any background noise, so I don't anticipate we'll have a problem today. So I should have two attorneys and a witness at all times with their cameras and microphones active for each examination. We'll now have the first witness for the prosecution. And Ms. Frau, who will you be calling?
Your Honor, the prosecution would like to call Detective Jordan Markowitz to the stand now.
And Detective Markowitz, we will assume that you are on the stand. Before I swear you in, if you would please give your character name and your student name.
Yes, Your Honor. My name is Sloan Smith, and I will be playing Detective Jordan Markowitz.
Thank you. Please raise your right hand. Detective Markowitz, do you solemnly swear or affirm under penalty of law that the testimony you're about to provide today in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Ms. Frau, please proceed.
Good morning, Detective. I'm Virginia Frau. Could you please state and spell your name for the record?
Of course. My name is Jordan Markowitz, M-A-R-K-O-W-I-T-Z.
Thank you. To begin, could you please tell me about your occupation?
Yes, I am a homicide detective with the Denver Police Department.
And how long have you been working with the Denver Police Department?
I have been with them a total of 13 years, and I have been a detective for the past 7 years.
And do you have any other certifications?
Yes, I have received a cell phone technology and forensic data recovery certification from the American Academy of Law Enforcement.
And what did that certification entail?
I took a 3-day certification training and certification test. The course covered types of cell phone data and records that can be obtained, how to use forensic data software, like the Celebrate system, which is to download and interpret data from cell phones, and how to acquire and interpret cellular records from a cell tower data.
And how have you used this training in your work?
I have downloaded the contents of approximately 100 cell phones and obtained and interpreted cell tower data from approximately 50 cell phones.
Your Honor, I move to enter Detective Jordan Markowitz as an expert in the fields of homicide, cell phone technology, and forensic data recovery on the basis of her training, experience, and certification in these fields.
So that would be homicide investigation and the cell phone issues?
Yes.
Okay. And Ms. Balani, any objection? Do you have any objection to either of those areas?
Yes, Your Honor, I would like to perform a voir dire on this witness.
Okay, and as to the two separate areas, the cell phone areas and the homicide investigation, first on the cell phone, you object to qualification there.
Yes.
What about homicide investigation?
Just the cell phone technology, Your Honor.
Okay, I will admit then Detective Markowitz as an expert in homicide investigation, and you may voir dire on the cell phone issues.
Detective, you testified that you have specialized training in cell phone data, correct?
Correct.
And to obtain this certification, you completed a 3-day training course?
Yes.
But it was only 3 days, correct?
Correct.
And other than that, you didn't mention any other education or training in cellular technology?
True, I just have experience.
And you've used this little amount of training in over 50 cases?
Yes.
No further questions. Your Honor, I request that this witness not be admitted as an expert in cellular technology because of her limited training and education in this field.
Ms. Frau?
Yes, Your Honor, expert witnesses only need to be qualified in one way, either in experience, training, or any other qualification. And my witness has been trained, has received a certification, and passed a test to be qualified in cell phone technology and forensic data recovery. She has also used this training in her job in over 100 cases.
And Ms. Balani, last word on the issue?
Nothing, Your Honor.
Thank you. I will qualify Detective Markowitz in both homicide investigation, which we've already addressed, and in the cell phone areas, cell phone technology, data recovery, and analysis. Her training may be brief, but her experience is large. You may be qualified in either area. She has some qualification in both. So I will qualify her in those areas. Ms. Frau, you may proceed.
Yes, Your Honor. To begin, could you please tell me how you came to be involved in the case of Mackenzie Breckman's murder?
Yes, I was assigned to this case in March of 2020.
Could you tell me about the initial details of this case?
Well, on Friday, March 6, 2020, a passing motorist reported seeing somebody possibly passed out on the porch of 444 South Flower Street. The paramedics responded, but upon finding the victim, Mackenzie Breckman, called for officers. Breckman was found just inside the front door of the residence, and uniformed officers secured the scene, and I reported at approximately 14:20 hours.
Objection, speculation.
And Ms. Frau?
These are simply the initial details of the case that could be found in police reports and the police detail calls that my witness was the lead detective on.
And Ms. Balani?
Was Miss Markowitz actually there when these initial details happened?
Well, that's a question that you might ask on cross, but the issue of whether or not it is speculation, it is simply a report that it was generated during the investigation. It may be someone else's speculation, but not this witness's. So I'm going to overrule the objection, and you may re-ask the question, Ms. Frau, if you wish.
That's all right, Your Honor. I'll move on. So, Detective, upon arriving at the scene, what were your first observations?
Well, when I arrived, I observed that the front door was open and the victim was face down on the floor just inside the residence. The victim was lying in a pool of blood and there was a large knife visible just past the body. The victim's shirt was blood-soaked around the upper left back and shoulder area, making it obvious that the victim had been stabbed. Because of the angle of the body, it appeared that the victim had most likely fallen to the ground while trying to leave.
Speculation.
And concerning the very last statement about how the victim got to the ground, is that the objection?
Yes, Your Honor.
And Ms. Frau?
Yes, Your Honor. My witness is qualified as an expert in the field of homicide. This is exactly why expert witnesses are allowed to speculate in matters that they are educated and qualified in. And this is simply what my expert witness is doing.
And Ms. Villani?
There's no way to know that this is what actually happened. This witness is simply speculating on what happened, which we don't know is the actual truth.
Fair enough. I think there's a counselor each trying to draw a fine line here between about speculation. I consider what Detective Markowitz has testified to is her expert opinion. It is based on fact, based on the circumstances of the position of the body after and before. I believe it is an opinion, not speculation. Objection overruled. Ms. Frau, you may continue.
Yes, Your Honor. Could you tell me what other observations you made at the scene of the crime?
Outside, I noticed that the side gate leading to the backyard was unlatched and the back door that leads to the kitchen was open. And the rest of the house was slightly in disarray, which could be a result of struggle or simply the normal state of the house. I also noticed that some parts of the kitchen were a bit disheveled, and there was a knife drawer wide open as well as a knife block with an open slot.
All right. What final observations did you make at the scene of the crime?
Well, there were several small drops of what clearly appeared to be blood on the floor of the dining room. From the dining room table, I could see that there was blood on the floor around the knife and what appeared to be cast off blood splatter on the wall and the ceiling near the door. I also noted that there was no other victims and expensive items such as a laptop computer and several flat screen TVs that were left undisturbed. And the dining room itself was in disarray. I found a broken plate lying next to the dining room table.
So based off of all the observations you made at the scene of the crime, what conclusions seem logical here in your expert opinion?
Based on the number of homicides I have investigated, it seemed fairly obvious that the victim had caught someone breaking into the home and had likely confronted the intruder with a large knife from the kitchen, but the intruder must have gotten control of the knife and stabbed the victim. It seemed most likely that the victim went to the front door after being stabbed, either running from or after the intruder.
So besides the evidence from the crime scene, what other evidence did you find important to this case?
Well, I always go where the evidence takes me and not where the case takes me. So we were also able to find Brackman's phone at the crime scene, which I then downloaded the contents of. And I found a tremendous number of texts and email messages related to something called mock trial. The t-shirt Brackman was wearing when he was stabbed said something about keep calm and mock on. And the front of the t-shirt had a high school mock trial logo on it. With a little digging, I found out that Brackman was a high school mock trial coach for Colorado High School.
So where did you go from there?
I reached out to the school and got contact information for all of the students on the team. I spoke to a student named Alex Cifuentes, who told me about some text messages that they received from another student on the team. Based on that, I had Alex Cifuentes and Cifuentes' parents come to the headquarters to conduct a full interview. It turned out that the other student was a senior on the mock trial team named Avery Becker. Brackman had recently kicked Becker off the mock trial team after Becker had vandalized Brackman's car. Cifuentes later sent me screenshots of the text messages from Becker.
Your Honor, may I share my screen to present Exhibit 14 to opposing counsel and my witness?
Yes, for introduction, yes.
Detective, do you recognize what is shown in these photographs?
Yes, these are the screenshots that Cifuentes sent.
Objection, hearsay.
Ms. Frau?
Your Honor, I don't understand what is hearsay in this case.
Your Honor, may I explain?
Yes, you may.
The screenshots are hearsay because we don't know that they are actually authentic.
All right, so it's the authenticity of the exhibit that you're talking about?
Yes, and the hearsay.
Ms. Frau?
Yes, my witness right now is proving recognition and will prove accuracy and accurate reflection, proving this authenticity of these photographs.
All right, could you ask, excuse me, could you ask Detective Markowitz if these are the records that she received?
Yes, Your Honor. Detective, do the contents of these photographs accurately reflect what Alex Cifuentes sent you?
Yes, they do.
All right, I'm going to admit this exhibit, Exhibit 14, as the screenshots that the detective received. The fact that she received them is not at issue. The credibility of these, the accuracy of these is not an issue about admission. It is an issue about the credibility of the person who sent them, Mr. Cifuentes. So that may be reserved for Mr. Cifuentes, other than clarifying that Detective Markowitz doesn't know anything other than what she received. So I will admit them with that caveat. The issue of their accuracy may be addressed at a later time. Let's proceed, Ms. Frau.
Yes, Your Honor. Detective, could you please describe what you see in these photographs?
Yes, of course. This is the text conversation that Alex Cifuentes told me about. These are screenshots that show Avery asking if he would talk to
Objection, hearsay.
And the objection to hearsay is to what statement?
Your Honor, the witness said that Avery said blank.
Okay. And Ms. Frau, you need to establish a foundation for how Detective Markowitz knows which side of these conversations, the gray or the green, is which person.
Yes, Your Honor. Detective, could you please tell us which speech bubble refers to which speaker in this context?
And most importantly, how she knows that.
And how do you know that?
Well, assuming these were the screenshots from Alex Cifuentes' phone, the green speech bubble would be Alex Cifuentes and the gray speech bubble would be Avery Becker.
Yes. So could you further describe what you see in these screenshots?
Yes. When Cifuentes refuses to talk to Brackman about letting Avery back on the team, Becker reveals his plan to break into Brackman's house and trash it.
All right. So how did you move forward with your investigation from here?
I obtained a warrant to search.
Narrative.
So far, if Detective Markowitz starts rambling, you may make that objection, but so far she has not.
Yes.
The mere question does not necessarily indicate that Detective Markowitz is going to provide a narrative. Let's see what she says. Detective, you may proceed.
Thank you. I obtained a warrant to search Becker's cell phone, but when I called Becker's attorney to make arrangements for said search, she said that Becker had lost the phone.
Objection, hearsay.
And Ms. Frau?
My witness is recounting the details of the case. What Avery's lawyer told my witness is within the scope of this case and the reports that my witness has done on this.
Ms. Villani?
Your Honor, that's fair.
Okay, the objection then is withdrawn. Let's, detective, please proceed.
Yes. Becker's lawyer told me that Becker had lost their phone on March 5th of 2020 and was no longer in possession of it. The attorney did provide me with the phone number for Becker's phone. So I got a
narrative.
Overruled. Let's let her finish her statement about the phone.
Yes, I got the phone number for Becker's phone, and I got a court order to obtain account records from Becker's service provider and also the cell tower records for March 6, 2020. The account records confirm that the phone number
Now let's have another question. Now that you've confirmed that you got the records, we need another question from Ms. Frau about what the result was. That would be a narrative. Let's proceed.
Yes, detective. What did you do next with these cell tower records?
In this case, the CDRs showed that another cell phone was sending several texts and placing several calls to Avery Becker's phone, leading up to the time that Mackenzie Brackman was killed. CDRs, or cell detail records, are used to locate Becker's cell phone at different times of the day of the murder.
Your Honor, may I now share my screen to present Exhibit 16 to my witness and opposing counsel?
16, yes. And the text messages were 14, is that correct?
Yes, Your Honor.
Thank you. So we'll now see 16 for introduction.
Detective, do you recognize what is shown in this photograph?
Yes, this is a diagram that summarizes what the call detail records from Becker's phone show.
And does this diagram accurately reflect what you found in those cell detail records?
Yes.
Your Honor, I move to enter Exhibit 16 into evidence.
And Ms. Bellani, any objection to 16?
Lack of foundation, Your Honor.
And Ms. Frau?
My witness has proved that this is a diagram compiled of the cell detail records which my witness obtained and investigated. I think there's plenty of foundation laid.
Ms. Bellani?
Your Honor, the witness has not established when or how she made these records.
I'm going to admit 16. She did not make these records. These records were provided, as she testified, by the cell company. She merely retrieved them. So I will, based on her testimony that she got these from the cell company, I'll admit them. You may proceed, Ms. Frau.
Yes, Your Honor. What does this diagram reveal about Becker's location on the day of the murder?
As you can see, the communications fell under 3 different cell towers. The first communication at 12:47 p.m. went through the cell tower at the top of the map, which covers Avery's house. The second communication went through the next cell tower at 2:55 p.m. The remaining communications at 13:05, 13:06, and 13:17 went through the last cell tower, which covers Brackman's house.
So what does all of this really mean?
The CDR data indicates that Becker was at home somewhere between 12:45 and 12:50.
Objection, speculation.
Ms. Frau, Detective Markowitz needs to indicate how she reached that conclusion.
Yes, Your Honor. Detective, how did you make these conclusions about what this diagram means?
Well, there was incoming communication to Becker's cell phone between these times, and the area of which these messages were received was in the area of Becker's house.
All right, continue.
Using this same information, we can assume that Becker left and drove towards Brackman's home, traveling.
Objection, speculation.
And Ms. Frau?
Yes, Your Honor. Again, my witness has proven that she's an expert in this field. This is her expert opinion about interpreting these call detail records. It's not speculation.
Ms. Balani?
We have no way of we can't establish that Avery was there just because her phone was there. Her phone cannot be made a direct connection to her.
Fair enough. Detective Markowitz may indicate that the phone owned by the defendant was in these places based on her opinion. Whether it was actually the defendant will need other witnesses. So Ms. Frau, you may proceed, and Detective Markowitz may proceed on that assumption.
Yes, Your Honor. So, Detective, continue telling us what this diagram means.
Well, the phone, then from 13:05 p.m. to 13:17, we can see that the phone was at Brackman's house. And this diagram also shows a possible route that the phone could have taken to get to Brackman's house that matches up with this data.
No further questions, Your Honor.
Thank you. And we'll pause for just a moment before we have cross-exam. And Ms. Balani, cross-exam on Detective Markowitz.
Thank you, Your Honor. Detective Markowitz, I ask that you keep your responses to a yes or no to the best of your ability. In your testimony, you stated that good police work requires following up on all potential leads, correct?
Yes.
Objection, Your Honor.
And the objection.
Hearsay.
I'm sorry.
Hearsay.
And what is your contention is hearsay here?
These statements were made in my witness statement, not in her testimony.
Your Honor, may I respond?
Yes, you may.
She's right. I meant to say her witness statement, but the witness did say this.
And a statement may be oral or written. I don't consider there's any difference there under the definition of statements. Oral, written, doesn't matter. Objection overruled. You may proceed.
Detective, you also stated that you believe that there's a possibility that the intruder in Brackman's house could have been the work of a disgruntled ex-client, correct?
Correct.
But you didn't follow up on these potential suspects?
No.
And moving on to our defendant, Avery Becker, you didn't choose to follow up on Becker's alibi, correct?
Correct.
And you also didn't follow up on the alibi of Taylor Perkins, who was with Becker when the murder occurred?
Objection, Your Honor. Argumentative.
Ms. Balani.
Your Honor, may I rephrase?
Yes, you may.
Detective, you didn't follow up on the alibi of Taylor Perkins, correct?
Correct.
In fact, you didn't investigate any potential witnesses that could confirm or deny these alibis?
Correct.
Now moving on to the people who you did choose to investigate, the first student from Colorado High School you interviewed was Alex Cifuentes?
Yes.
Cifuentes came to you with the claim that Becker was allegedly planning to trash Brackman's house, correct?
Yes.
And Miss Cifuentes didn't bring their phone to the interview?
No.
Did you find this odd?
Well, sometimes you forget things, and Cifuentes forgot their phone, and I think that's acceptable.
And you had Cifuentes take screenshots of the conversation between them and Becker, correct?
Correct.
But you didn't receive these screenshots until the day after your interview with Cifuentes?
Correct.
And you didn't choose to obtain evidence of the text messages yourself?
Correct.
And you only saw the screenshots of the actual text messages, correct?
Yes.
Detective, are you aware that there is technology available to recreate fake screenshots?
Yes.
Moving on to the defendant, Avery Becker's phone. Though you were never able to physically retrieve Becker's cell phone, you were able to obtain its records.
Yes.
And based primarily off of these cell phone records, you assume that Becker was at all the same locations?
Yes.
You also discovered that those records indicated another phone attempted to contact Becker's phone, right?
Mm-hmm. Correct.
And you confirmed that that phone belongs to Taylor Perkins?
Yes.
But you didn't follow up on why Perkins' phone was calling Becker's?
No, I did not.
Moving on to missing evidence. You were unable to present all the pictures taken at the crime scene.
Correct.
And that's because the files somehow became corrupted?
Yes.
But you aren't aware of how this happened?
I am not, no.
So, Detective Markowitz, based on what we have heard, you did not follow up on all potential suspects.
I did not.
And you didn't follow up on potentially key witnesses?
No.
And potential evidence?
No.
No further questions, Your Honor.
Thank you. We'll pause for a moment before we have redirect. And Ms. Frau, you may redirect your witness.
Yes, Your Honor. Detective, did you have any reason to believe that Alex Cifuentes would be lying?
I did not.
And did you think that it was suspicious that Avery Becker requested that all communications go through her lawyer?
Yes, I did.
So would you say that that established trust between the two of you?
Yes.
You would say that Avery asking all communications to go through her lawyer established trust?
Oh, sorry,
Objection,
no.
leading question.
And the objection is?
Leading question.
As to a leading question, although it was a clarification by the witness to the attorney to clarify the question, I don't consider that leading. As to that objection, overruled.
So,
and Ms. Frau, you may continue.
So, Detective, you had reason to believe, did you have reason to believe that Avery Becker could be lying about his whereabouts on the day of the murder?
Yes.
Objections.
Other questions, Your Honor?
I'm sorry, you cut out there for a second. The objection is?
Speculation, Your
Honor. Ms. Frau?
Yes, Your Honor. My witness is an expert in homicide investigation. This is her job and she's been qualified this way. I think it's well within her expert opinion to make this conclusion.
This is the same issue that was raised earlier. I consider this not speculation, but Detective Markowitz's opinion based on specific facts. It is an inference, not speculation. Overruled. You may proceed, Ms. Frau.
No further questions, Your Honor.
And we'll pause just a moment before recross, if any. And Ms. Bolani, you may recross this Detective Markowitz.
Thank you, Your Honor. Detective, you never saw the text messages in person, correct?
That is correct.
And do you have any proof that they are authentic?
No.
No further questions, Your Honor.
Thank you. And Detective Markowitz, you are excused. And we will pause for a moment before we have the prosecution's second witness so that the jury may collect its thoughts. And Ms. Fitzsimmons for the prosecution, if you would call your next witness.
Thank you, Your Honor. The prosecution would like to call Ms. Kyle Kuzak to the stand.
And Ms. Kuzak, if you could please state your character name and your student name for us.
My name's Mallory Coughlin, and I'm Kyle Kuzak.
Thank you. And Ms. Kuzak, if you please raise your right hand. Do you solemnly swear or affirm under penalty of law that the testimony you're about to provide today in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And Mr. Rowe, you may proceed. Oh, I'm sorry, Ms. Fitzsimmons, you may proceed.
Good morning. To start off, will you please introduce yourself to the jury?
Yes. Hi, my name is Kyle Kuzak. That's Kuzak.
Thanks, Ms. Kuzak. And what do you do for a living?
I'm a crime scene reconstruction investigator. It's also known as CSR.
Are you a police officer then?
No, I'm not a police officer. I'm just a civil employee for the Denver Police Department.
And do you have any certifications?
Yes, I'm certified by the Colorado Bureau of Investigation for crime scene reconstruction.
And what's your experience in this field?
I have 19 years of experience investigating homicides, attempted burglaries, armed robberies, fatal accidents, and I've spent the last 3 years of my tenure with the city of Denver.
Your Honor, I move to enter Ms. Kyle Kuzak as an expert witness in the field of crime scene reconstruction on the grounds of her many years of experience and her certification by the state of Colorado.
Does that include investigation as well as reconstruction, or just reconstructing the scene?
Crime scene investigation and reconstruction.
All right. And Mr. Rowe, any objection to that area of crime scene investigation and reconstruction?
Yes, I would like to object to their lack of certification, and I request to voir dire the witness.
And you may.
Kyle Kuzak, you are not a police officer, but a civilian, correct?
Yes.
And you have only been with the city of Denver for 3 years?
Yes, but I have 19 years of experience working, doing things just like this with others.
Okay. And do you have any documentation with you today over your experience in this field?
No.
The defense objects to the admission of Kyle Kuzak as an expert witness based on their lack of experience and certification.
And Ms. Fitzsimmons?
Your Honor, as my witness testified, they have 19 years of experience investigating and reconstructing crime scenes, and they are also certified by the Colorado Bureau of Investigation as a crime scene reconstruction investigator.
Mr. Rowe?
That still does not change the fact that they are merely a civilian and have only been with the city of Denver for 3 years.
I will qualify Ms. Kuzak as an expert in crime scene investigation and reconstruction, although her formal certification is minimal. Her experience is broad, just as our previous witness, but under the rule that may also qualify her. It is up to the jury to weigh whether what credibility to give to her testimony. Although she is qualified to give that testimony, the jury may weigh the credibility of that testimony based on any experience she does or does not have, but she does have enough to be qualified. So I will qualify in crime scene investigation and reconstruction. Ms. Fitzsimmons, you may proceed.
Let's move on to the afternoon of March 6, 2020. Were you present at the scene of the homicide at 444 South Flower Street?
Yes, I visited the scene after it was processed by other members of the crime lab, and I also reviewed all police reports, photographs, and the ring security cameras.
Great. Can you please describe the sequence of events shown in the videos from the victim's ring security cameras?
Yes, so they started on March 6, 2020, and it showed a perpetrator matching the general height and build of the defendant approaching the victim's residence by the front door. They attempted to enter through the front door, but after realizing it was locked, moved around to the side door, or moved around to the south side of the house, And they were picked up a few seconds later by a second ring security camera approaching the back the back fence of the house. They then were lost out of range of that camera, and about 10 seconds later were picked up by the third security camera on the back side of the house, entering the sliding glass door of the residence.
And Your Honor, may I have permission to share my screen and show the opposing counsel and Ms. Kuzak exhibits 7, 8, 9, and 18?
7, 8, 9, and 15?
18.
18. Yes, for introduction, you may show the 4.
All right, Ms. Kuzak, beginning with exhibit 18, may you please describe this?
Yes, that is the floor right by the sliding glass door where the perpetrator entered, with a few scuff marks on it.
And what is the exhibit's relevance to this case?
I believe that this shows that there was some kind of struggle that started between the victim and the perpetrator when the—
Before we have an opinion from your expert, I need to get this introduced or admitted. It has been introduced but not admitted, so she needs to lay a foundation and then get it admitted.
Yes, Your Honor. Is this exhibit how you remember it?
It is.
And has it been altered in any way?
No.
Your Honor, permission to move exhibit 18 into evidence?
And Mr. Rowe, any objection to 18?
I object on the basis of a lack of foundation on this exhibit, as we have no idea what the relation of this is to the actual crime.
Well, the relevance will be decided by testimony once it's admitted. Do you have any objection to its authenticity, that it is from the crime scene?
No, I do not.
And it's admitted 18. Let's move on.
Thank you. Now, Ms. Kuzak, in your expert opinion, what is this exhibit's relevance to the case?
I believe that it shows some kind of struggle that happened between the perpetrator and the victim once the perpetrator entered through the sliding glass door.
Thank you. And now I'm going to move on to show exhibit 7. Sorry. All right, Ms. Kuzak, can you please describe this?
Yes, it is one of the knife drawers in the victim's home with a couple of large knives as well as other kitchen utensils in it.
And is this how you remember it when you showed up to the scene of the crime?
It is.
Has it been altered in any way?
No, it has not.
Your Honor, I move to enter exhibit 7 into evidence.
Mr. Rowe, any objection to 7?
I object on authenticity because the Ms. Kuzak was at the crime scene after it has been processed, so we have no way of knowing this is how it was before.
Ms. Fitzsimmons, could you ask Mr. Kuzak if he took this photo or it was presented to him by the other investigators?
Yes. Ms. Kuzak, did you take this photo?
No, I did not.
And may we move it into evidence?
Well, need to know who did.
All right, who took this photograph, Ms. Kuzak?
I believe it was the police officers who were at the scene of the crime right after it happened.
And who she got it from?
And where did you get it from?
Jordan Markowitz.
Mr. Rowe, with that foundation, any objection?
I remove my objection of authenticity.
Thank you. 7 is in. Let's move forward.
Thank you. And next, moving on to exhibit 8. Ms. Kuzak, may you please describe this exhibit?
Yes, this is a knife block on the victim's kitchen counter with a slot missing.
And did you take this picture?
No, I did not. It was given to me by other members of the investigative team, specifically Detective Jordan Markowitz.
And is this how it was when you arrived at the scene of the crime later?
It was.
Has this exhibit been altered in any way?
No, it has not.
Your Honor, permission to move exhibit 8 into evidence.
Mr. Rowe, as to 8?
Your Honor, I object to the relevance of this exhibit, and I also do not see I also see a lack of foundation in regards to the knife block.
Okay, as to the photo and the foundation laid, taken by an investigator and given to Mr. Kuzak, I will allow it in. Relevance will depend on testimony. Once it's admitted, it is now admitted. Ms. Fitzsimmons, you may proceed.
Thank you. And What is the significance of these two images, Ms. Kuzak?
I believe that it shows the victim first started digging through the knife drawer to find a weapon to arm himself with, and then moved to the knife block where he picked up that knife. And the empty knife slot is where the knife pulled out of the victim's body was.
And why do you believe this?
Because the kitchen drawer was open and the knife matches the same size as the knife that would be in the knife block.
All right, and now finally we're going to move on to Exhibit 9. What is shown in this?
It is a broken plate in the kitchen of the victim's residence.
Your Honor, permission to move. Oh, sorry. Did you take this photograph, Ms. Kuzak?
I did not. It was given to me by other members of the investigative team, specifically Detective Jordan Markowitz.
And was this true to how you remember it at the crime scene?
It is.
Has it been altered in any way?
No.
Your Honor, permission to move Exhibit 9 into evidence.
Mr. Rowe, as to Exhibit 9.
I have no objections.
Exhibit 9 is in. You may proceed, Ms. Fitzsimmons.
Thank you, Your Honor. Now, Ms. Kuzak, are you aware of Professor Blake Van Owen's theory for the murder?
I am aware of Professor Blake Van Zoen's theory that the victim was startled by the intruder and stabbed in the back while sitting at his kitchen table.
And what do you think of this theory?
I think there are a lot of holes in the professor's theory. It doesn't account for any of the evidence, the broken plate, the scuff marks, the open drawer, the empty slot in the knife block, and the perpetrator would have had to been holding the knife completely wrong from just about anyone who picked up a knife to stab someone.
Thank you. And now for your conclusion on the case. Where do you believe that the victim started?
I believe that the victim started inside his home and then was alerted by the Ring security camera notifications that someone was trying to enter his home, and then, moved to the side of the house.
And what do you believe the victim did next?
I believe that then, after the victim was notified of the intruder, she went to his kitchen and first dug through the knife drawer and then proceeded to take the knife out of the knife block to arm himself as the intruder entered through the sliding glass door.
And what did you conclude happened after the intruder entered the home?
I believe that some kind of struggle started between the victim and the perpetrator over the knife, and somewhere between the back door and the kitchen, the knife became in the intruder's possession.
So how did the intruder kill the victim?
I believe that there was a slight struggle, and then the victim would have been the victim would have been holding the perpetrator in some kind of bear-like manner, trying to get the knife back, and that's when the perpetrator would have stabbed him in the back with the knife.
Lack of foundation. The witness has never testified to this previous in their current testimony. So they cannot put it as a part of their final conclusion as of right now.
Ms. Fitzsimmons?
Your Honor, as she is certified, or as she's been admitted as an expert witness in crime scene reconstruction, I believe she's just trying to give her theory of what happened during the crime.
Is this part of the statement of Ms. Kuzak? Can she testify this as opposed to someone else?
Yes, Your Honor.
It's part of her statement?
Yes.
And Mr. Rowe, is that correct?
Yes, but may I quickly respond?
Yes, you may.
This witness has not made any testimony here today to show that this happened. So I was objecting to the lack of foundation because they cannot bring that up now if they have not talked about it.
Understood. I understand the objection. I'm going to overrule the objection based on the foundation in the opinion that Ms. Kuzak has made about the entry, the struggle, the scuff marks, the orientation of the people, and the knife. She can give her opinion. It may or may not be credible to the jury, but she may give her opinion. Overruled. Ms. Fitzsimmons, you may continue.
Now, after sequencing the events in this case, what conclusions did you reach?
It's clear to me that this was a planned burglary gone wrong. The perpetrator had prior knowledge of the victim's residence and property and obviously chose a time when the victim's activity would have put him outside the home. However, the victim ended up being at home and the ensuing struggle that happened ended up costing the victim his life.
Thank you, Ms. Kuzak. No further questions, Your Honor.
We'll pause for just a moment before we have cross-exam. And Mr. Rowe, you may cross-examine the witness.
Thank you, Your Honor. Ms. Kuzak, I'm going to ask you to refrain to a series of yes or no answers unless it has already been implied that you do not need to answer yes or no. Do you understand?
Yes.
Ms. Kuzak, did you visit the crime scene?
Yes, after it was processed.
And the crime scene was processed, or you claim the evidence did not give you a complicated fact pattern, or in other words, was easy.
Yes.
And you claim that your CSR, or certified crime scene reconstruction process, is very accurate and efficient.
Yes.
Based on your reconstruction, the first event was the perpetrator attempting to enter through the front door, correct?
Yes.
And the perpetrator was wearing a mask and gloves, preventing anyone from seeing the face of the perpetrator.
That's correct.
And there was no DNA or fingerprints ever found at the scene.
No, just the victims.
Did it take the perpetrator around 10 seconds to get from the gate to the back door?
Yes, around then.
And in this time, you believe that the victim, Mackenzie Brackman, was notified, recognized the threat, and armed themselves in this short period of time.
Yes, the victim moved from the front door to the gate to the back door.
Did you just say that the victim moved from the front door to the gate to the back door?
Yes.
It was the perpetrator. The victim
I'm sorry.
was inside the house. Okay, understand.
Sorry.
Specifically, though, Mackenzie Brackman was notified by the Ring doorbell and security cameras in that time frame.
Yes.
Okay. Did you ever look into Mackenzie Brackman's phone to see if his Ring notifications were on?
No.
And moving on, you believe that there was a struggle between Brackman and the perpetrator.
Yes, I believe that's what the evidence points to.
And a plate got knocked over and broken, and scuff marks were created during this struggle.
Yes.
Are there any other ways that plates can get broken or scuff marks can be made?
There are, but I believe that it was from a struggle.
And can you know exactly when the scuff marks originated?
You cannot, but again, this is what I have conducted in my investigation. That's what I believe.
Was the knife that was used to stab Mackenzie Brackman a Chicago cutlery chef's knife?
I believe so, yes.
And this knife did not match the knife block?
I believe it matched the knife block.
Your Honor, I would like to impeach this witness, and I request my co-counsel to bring up the Ms. Kuzak's witness statement using screen share.
And that's fine.
So now I request my co-counsel to bring this up. Okay. In the witness statement, can you go to lines 152?
And let's first have an identification of the statement, make sure this is her statement.
Yes, you can see at the top that it is Kyle Kuzak's expert witness statement.
And through the witness, please.
Ms. Kuzak?
Yes, this is my statement.
Thank you.
Okay. Ms. Kuzak, when we get there, can you read lines 148, starting at the recovered knife, to line 153, ending at J.A. Henkel's knife set?
I'm sorry, which line should I start with?
148, starting at the recovered knife.
The recovered knife easily matches the incision and the path of the victim's wound. It was a Chicago cutlery Chicago cutlery knife with a metal handle. The knife was cast from a single piece of metal. Its total length is 12 inches and the blade section measuring roughly 7.5 inches in length and approximately 2.5 inches across at its widest point. The knife and the knife blocks and the block itself are a more expensive J.A. Heckles knife set, but it would not be unusual for a
That's
person.
all I asked you to read, Ms. Kuzak. Thank you. Did this refresh your recollection in regards to my last question?
Yes, but I said later in my statement it's completely normal for someone to put different knives in their knife block.
Yes, but I did not ask of you to read that. So I'm going to re-ask my previous question. Co-counsel, you can stop screen sharing. So Ms. Kuzak, did the knife match the knife block? Yes or no?
It did not match the brand the knife block was, no.
And were the knives in the knife block and the knife block itself from a more expensive J.A. Henkel's knife set?
Yes, but that doesn't mean the knife block exclusively holds those knives. People can
Ms.
switch them out.
Kuzak, I'm asking you to refrain to yes or no's, and you have previously agreed to this. So can you please courteously continue doing that?
Of course.
Thank you. So the J.A. Henkel's knife set was more expensive than the chef's knife used, correct?
Yes.
So the Chicago cutlery knife was less expensive.
Yes.
Okay. Is it true that you read over how Blake Van Owen believes Brackman was stabbed?
Yes.
And you disagree with this conclusion?
I do. I think it doesn't account for all the evidence.
Do some of Blake Van Owen's conclusions fall outside of your area of expertise?
I believe some of them do, but most of them fall within my expertise.
Okay. From day one, did you memorialize, document, and organize all of your evidence?
I did.
Yet blood splatter and blood cast-off photos were lost despite this effort?
Yes, but I had seen them before they were.
Okay. Did you look into all leads in this case?
I put them all in my 7-step process, but I specifically looked mostly into Avery Becker.
So you did not look into Blair Rollins?
No, I felt the evidence pointed more towards Avery Becker.
And you were not able to recreate all event segments and place all evidence in this case?
No, but that's completely normal.
Okay. No further questions, Your Honor.
We'll pause a moment before we have redirect. And Ms. Fitzsimmons, you may redirect your witness.
Your Honor, the prosecution will save our time for the next direct examination, please.
All right, without redirect, there will be no recross. So Ms. Kuzak, you are excused. Thank you. And we'll now pause for a moment before we have the prosecution's third and final witness. And Ms. Frederick, for the prosecution, we'll now have the next witness.
Thank you.
I'm sorry, I mispronounced your name because I miswrote it. It is Fendrich. Ms. Fendrich, again, the next witness.
Thank you. I call Alex Cifuentes to the stand. And before we begin, may I have a time check, please?
Yes, you may.
Thank you.
And I will assume that Ms. Fuentes is on the stand. Ma'am, if you would introduce or give your character name and then your actual student name, please.
All right. I'm Olga Serbala, and today I'll be playing Alex Cifuentes.
And Ms. Cifuentes, if you'd please raise your right hand. Do you solemnly swear or affirm under penalty of law that the testimony you're about to provide today in this matter will be the truth, the whole truth, and nothing but the truth?
I'm sorry, you cut off.
Oh, do you solemnly swear that the testimony you're about to provide today will be the truth, the whole truth, and nothing but the truth?
Hello?
Did you hear me that time? Ms. Cifuentes, looks like you're having a little connection problem. You can put your hand down. There we go. Whoop. She's connecting again
All right.
there. So, did you hear me?
Okay.
Did you hear my statement swearing you in?
Yes, I did.
And do you so swear?
Yes. Yes, I do.
And Ms. Fendrich, you may proceed.
Thank you. And before we begin, I request that any time lost for connectivity issues be not counted against us.
Of course not, and my swearing in does not obviously count against your time. So you'll now begin your time, I think 3 minutes and 19 seconds, and please begin.
Yes, thank you, Your Honor. Good morning. To begin, can you please introduce yourself to the jury?
So sorry. I think I'm having connection problems because I cannot hear you. I'm so sorry.
That's all right. Would you like me to repeat the question?
Hello?
Oh.
Okay.
Is there a problem on my end? Am I able to be heard?
Yeah, I believe it is on Ms. Sorbala's end. Can you hear me, ma'am? She's going to try to reconnect.
Okay, thank you.
So we'll start your time when I indicate to the timekeepers, we will start your time.
Okay.
And Ms. Sorbala, can you hear me? Not well. Ms. Sorbala, can you hear me? No.
Hello?
Ms. Sorbala, can you, is there a way that you can, without video, connect by telephone, by cell phone?
No.
I know there is a way to do that on Zoom. I don't know if you're aware of it. We can do without your video if you can connect by cell phone, just your audio.
I'm sorry?
Are you aware of how to connect by cell phone without video?
I didn't hear the last part. Here,
Okay.
wait.
Your Honor, if I may speak freely for a moment, I believe we could also use the chat in order to communicate with her in terms of connection issues as well as to get the information out to her.
Good point. If she has that connection. Ms. Sorbala, are you still on?
Oh, I can hear you now. All right.
Can you hear me fine? Or can you hear me well to be?
Hello?
Yes, Ms. Sorbala, can you hear me?
Yes, I can hear you.
All right. I think we will go ahead with the examination with audio and not visual. Is that acceptable, Ms. Fendrich?
That is.
And Ms. Sorbala, is that acceptable to you?
Yes.
And Mr. Kunath?
I have no concerns in regards to this, Your Honor.
Okay, good. We'll go ahead and start the examination then. Again, 3 minutes, 19 seconds. Ms. Fendrich will assume that Ms. Cifuentes has introduced herself. Let's proceed with the examination.
Now, Alex, what high school did you attend last year?
Well, this year I'm a senior at CHS.
Do you have any extracurricular involvement at school?
Yes, I'm in mock trial. Go Mockers!
Do you enjoy that activity?
Yes, it's really fun, and I think I'm really good at it.
Would you say that you take it pretty seriously?
Yes, of course. I practice in front of
Objection,
mirrors
relevance.
with friends.
The objection is relevance. I'm going to permit this as background as to her participation. Overruled. You may proceed.
Thank you, Your Honor. I will repeat my question. Would you say that you take this activity pretty seriously?
Of course, I practice and I do everything in my power to be the best that I can.
Were there any students on the team that didn't take it seriously?
Yeah, Avery Becker didn't take it as seriously as me. She was always late and unprepared.
What was your relationship like with Avery Becker?
Well, we were really good friends, basically best friends. She's the one that got me mock trial in the first place.
Did anything happen to affect that relationship?
Well, yeah, she wasn't a good teammate. She was always late and unprepared, and not a lot of people liked her because of this.
Would you say that your coach, Mr. Brackman, from your viewpoint at least, had a very good relationship with Avery?
No.
Objection, speculation.
The objection is speculation. Ms. Fendrich.
Your Honor, I'm asking my witness to recall from her memory and from her perspective if she noticed any tension between the two. I'm not asking her to make an objective statement whatsoever.
Mr. Kuneth.
Your Honor, in terms of speculation, I don't believe that Alex Fuentes can fully describe the relationship between Avery Becker and Mackenzie Brackman.
Fair enough, but I'm going to overrule the objection to the extent that Ms. Cifuentes can testify to her observations and her conclusion based only on those observations, not upon any subjective intent of the two other people, but just on her observations. You may continue.
Thank you, Your Honor. I'll repeat my question.
Yeah, like I was saying, during practice, you could obviously see that they didn't have the best relationship. They were always in fights, and Mr. Brackman was always on to Avery about something.
Were there any notable conflicts between the two that you've noticed or that stood out to you?
Yeah, there was this one conflict when Avery came to practice for late for the up 10th time, and Mr. Brackman demoted her to B team, which I thought was pretty reasonable.
What happened after that?
Well, after that, Taylor Perkins quit the team so Avery would get back onto it.
And what happened next? What did Avery do?
Well, Avery went to the regional tournament, and then she won Best Attorney and Best Closing Statement Award, which I thought was not a good choice. Well, it just irked me so much.
Objection, improper lay opinion.
Ms. Fendrich, the objection is improper lay opinion. Do you have a response?
Your Honor, seeing as my witness was on the mock trial team, they would be privy to conversations and understandings about the circumstances of the relationships of their teammates, as well as what went on during these competitions. And so I see it as entirely relevant and appropriate for my client to be able to testify to this.
Mr. Kuneth?
I stand by my objection, Your Honor.
I believe this is proper lay opinion based only on her observations of, as indicated earlier, just her observations of what was going on, the dynamics. I'll overrule the objection. Ms. Fendrich, you may proceed.
So, Ms. Cifuentes, how did Mr. Brackman feel about Avery's performance?
I'm sorry?
How did Mr. Brackman feel about Avery's performance at the regional tournament?
Oh, there was a huge fight after. Mr. Brackman said that Avery should practice more and that this is a malpractice in the real world, which I totally agree. So after that, Avery got really upset.
What did Avery do?
She stormed out and grabbed a Sharpie and vandalized Mr. Brackman's car. Can you believe that?
Is there any way that this incident was an accident?
Well, a Sharpie and a dry erase marker look pretty different. I saw her specifically grab a Sharpie.
I see. And considering the time that I have left, I have no further questions, Your Honor.
Thank you. We'll pause for a moment before cross. And Mr. Kunith, you may cross-examine the witness.
Thank you, Your Honor. Ms. Fuentes, I would like you for the following responses to these questions to be limited to a yes or no response. Do you understand the implications of this?
I will try my best, yes.
Is that a yes or a no?
We'll stop time for a moment. You may, counsel may ask on both sides. If the witnesses are able to answer yes or no, you may not confine it to that. You may not get a promise to do that, no. Witnesses may answer as they will. You may request that they attempt to limit their testimony to yes and no on cross, but those are the rules of the court. So you may proceed and time may begin again.
Thank you, Your Honor. Now, I'd like to first start off with your relationship with Avery Becker. You did not appreciate the way Becker treated your teammates, is that right?
No, she was not prepared.
You think Avery always played the victim, right? Ms. Fuentes?
I'm sorry, can you repeat the question? You cut off.
Yes. You think Avery always played the victim, is that correct?
Yes.
And you did not like how Avery would make up things on the spot on direct examinations, is that correct?
Yeah.
And you think it's unfair that Avery won the Best Attorney Award at the regional tournament?
Yeah, because she didn't put much work into it, and I did, and I should have won it.
And you also think it's unfair that Avery got the Best Closing Argument Award at the regional tournament?
Yes.
And so you think that Avery does not work hard?
Objection, Your Honor, asked and answered.
It was phrased a little bit differently. I'll allow the question just as a follow-up, overruled. You may ask the question again, Mr. Kunith.
Thank you, Your Honor. You think Avery does not work hard?
Yes.
And you thought that Avery won the award solely based on her looks?
I'm sorry, can you ask again?
Yes, of course. And you think that Avery won these awards solemnly based on her looks, is that right?
Yeah, because she didn't come prepared. So I think that she was won on unpreparedness and her looks.
Now I'd like to move on to Brackman's vehicle. You thought that Brackman should have pressed charges when Avery wrote on Brackman's vehicle. Is that correct?
Well, I didn't think so. I just thought that it was a very noble thing of him to do to not press charges.
After Avery wrote on Brackman's car, Avery got removed from the mock trial team. Is that right?
Yes.
And you thought the team was better than Avery?
Objection, Your Honor, argumentative question.
Mr. Kunith?
Your Honor, Ms. Fuentes does state that in their witness statement.
And Ms. Fendrich?
I stand by my objection.
All right, I do not think it's argumentative. It is her opinion, but that doesn't necessarily mean it's argumentative. So overruled, Mr. Kunith, you may re-ask.
Mr. Fuentes, you thought the team was better without Avery, correct? Please excuse me for the previous.
I'm so sorry. You interrupted. You cut off? Would you re-ask? Sorry.
Sure thing. Mr. Fuentes, you thought the team was better without Avery, correct?
Yes.
And someone would have to fill Avery's place on the team, correct?
Oh, I'm so sorry.
Do you need the question again, Ms. Cifuentes?
Yes, please.
Yes, of course. Someone would have to fill Avery's place on the team. Is that right?
I I did not hear it. I'm sorry. I'm having connection problems. I'm so sorry.
No worries. Would you? All right. Someone would have to fill Avery's place on the team. Is that right?
Yes.
And with Becker kicked off the team, there was a space open for the A team. Is that correct?
Yes.
And with that, you'd have the possibility of a larger role within the team. Is that correct?
Objection, Your Honor, relevance.
Your Honor, may you respond?
Yes, you may.
Your Honor, this is absolutely pertinent between the relationship with Avery Becker, Alex Cifuentes, as well as Mackenzie Brackman on the team, considering their reliability as part of the team.
Ms. Fendrich?
I see no reason as to how my witnesses' relationship with their team and their standing on the team is related to the death of their mock trial coach.
Your Honor, may I respond briefly?
Yes.
In terms of the relationships between the two, the relationship between Avery Becker and Mackenzie Brackman is essential towards whether or not Avery Becker committed these crimes or not, or if it was someone else.
I'm going to overrule the objection. The issue is not whether it's related to the death of the teacher, it's the credibility of this witness and whether this witness has bias against the defendant. So overruled, and Mr. Kuneth, you may proceed. And I just want to make sure that the timekeepers, I saw a time flash up there, that time does not run during these objections, of course. So let's proceed.
Thank you, Your Honor. Now, with Becker kicked off the team, you would have a larger role in mock trial. Is that correct?
And Ms. Cifuentes, do you need the question again?
No. Yes, I would have a larger role on the mock trial team if Avery was off the team.
And you stated that you were excited for the larger role now that Avery was gone.
Of course. Why wouldn't I be?
No further questions, Your Honor.
We'll pause a minute before redirect. And if we could have a quick time check on redirect. I don't know that there is any time, but just a time check.
I believe there is no time for redirect, Your Honor.
All right, without time for redirect, there will be no recross. Ms. Cifuentes, glad to see you again.
Yeah, I repositioned closer to the router. That.
Okay. Well,
yeah.
In any event, no more questions or excuse. Thank you very much.
Thank you.
You bet. And we will pause for a moment before we move to the defense case. And for the prosecution, we will now have the first, I'm sorry, for the defense, we will now have the first witness.
Thank you, Your Honor. Before I proceed with calling the first witness, I just want to make sure that prosecution has no more witnesses to call and rest their case.
And
Prosecution rests our case.
thank you. And I apologize for not doing that. It's been 5 weeks since I've been a district court judge. I've
It's
getting
totally okay, Your Honor.
rusty in my old age.
It's fine, Your Honor.
The prosecution has rested, and Mr. Rowe, your first witness.
Thank you, Your Honor. The defense would like to call their first witness, Avery Becker, to the stand.
And we have Ms. Becker, and do we have prosecution counsel? Yes, we do, Ms. Frau. Now, if you could introduce yourself, Ms. Becker, both your character name and your student name.
Hi, I'm Ananya Shrestha, and I'm playing Avery Becker.
Now, Ms. Becker, you are the defendant in this case. You have been charged with a crime. Are you aware that you have a right under the Fifth Amendment to the United States Constitution that you have no obligation to testify? You have a right not to testify. Are you aware of that?
Correct, yes.
Are you also waiving that right by testifying here today with full knowledge?
I am, Your Honor.
Okay. If you'd please raise your right hand. Do you solemnly swear or affirm under penalty of law that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Rowe, you may proceed.
Ms. Becker, can you state your first name and spell the last for the record?
Good afternoon. My name is Avery Becker, Becker.
Thank you. Ms. Becker, where did you go to school last year?
I was a senior at Colorado High School.
Were you involved in any clubs, activities, or extracurriculars at your school?
Yes, I was. I was on mock trial for 4 years.
Why did you decide to participate in mock trial?
My friend Taylor and I thought it was a fun way to get out of the house and hang out. I also got to use my phone at mock trial, which was something I couldn't do at home until I finished my homework.
Who was the coach of the mock trial team?
Mackenzie Brackman, who is now tragically dead.
How was your relationship with Brackman?
I mean, we never really got along, but I respected him as a coach. He would always call me out and yell at me for being lazy and not preparing, which caused a lot of arguments and disagreements between us.
Did you get into any trouble with Brackman?
I did, because I didn't prepare. I remember one time before regionals, he saw I really wasn't prepared, so he bumped me down to the B team, which is where the less experienced team members tend to end up.
Did you ever get back onto the A team in mock trial?
I did.
How did you do this?
My friend Taylor Perkins, she wasn't really a fan of mock trial, so she's quit, and because there wasn't enough time to train someone else, I got put back on the A team.
In mock trial, are there any forms of competition?
Yes, we have tournaments.
And how did you do at the most recent tournament?
I did really well. I received the best attorney and the best closing awards.
How did Brackman respond to your success at the competition?
He wasn't happy. He said I didn't deserve my best attorney award and
Objection, Your Honor, hearsay.
Your Honor, may I respond?
Yes, you may.
The declarant is currently unavailable, and this is also Avery Becker's present sense impression on how they observed Brackman respond.
Response, Your Honor.
Ms. Frau.
I believe present sense impression is used to recount what somebody said in a certain situation, which was their present sense impression. As in, like, if you see a dead body, you say, oh, that's a dead body. That would be present sense impression. I don't believe that applies here.
What about the dead man statute about he's not available, and also the rule of evidence of unavailability of a statement? Any response there?
No response, Your Honor.
All right, I will allow it. The decedent, of course, is not available for testimony. I will allow that statement as his by representation. Mr. Rowe, you may proceed.
Ms. Becker, would you like me to re-ask that question?
Yes, please.
So how did Mackenzie Brackman respond to your success at the competition?
He wasn't happy. He said that I didn't deserve the best attorney award and that I was relying on my good looks, and he yelled at me for being unprepared, again, in front of everyone.
After that response, what did you do?
I got really upset and I insulted him, and I ended up storming out of practice with what I thought was a dry erase marker because we were using it in practice. And I saw Brackman's car outside, and I wrote the worst attorney award on his car.
What did you think you wrote this message with?
At the time, I thought it was dry erase marker, and I really never would have written anything like that in permanent marker if I knew it was permanent.
Did you have any intent to ruin Brackman's car?
Absolutely not. I would not have done it if I had known that it would leave permanent harm.
Did you observe Brackman respond to the message?
Yes, I did. He was really mad and he kicked me off of the mock trial team.
The next morning, what did you decide to do?
I went to Brackman's office to apologize in person, but his secretary said he didn't want to talk to me, so I left.
What did you do after you left his office?
I texted him apologizing. I even offered to scrub his car or to get a summer job to pay it off, to pay for it to be repainted, but he never responded, so.
Okay. On March 5th, 2020, the day before Mackenzie Brackman was found deceased, did you go anywhere?
I did. I went to the Fry Shack and the mall with Taylor Perkins.
Did you see anybody else at the Fry Shack?
Yes, the Fry Shack is where a lot of mockers or mock trial members hang out, so we ran into some of them, including Alex Cifuentes.
Okay. Did you have anything with you while you were with Alex Cifuentes?
Yes, I had my phone.
And what did you do with your phone while you were talking to Miss Cifuentes?
I just set it on the table and I was playing video games on it, but while I was talking to Cifuentes, I put it on the table.
And what did you talk to Miss Cifuentes about?
We talked about me getting kicked off the team. Alex started to apologize about it, but...
Objection, Your Honor, hearsay.
And Mr. Rowe?
Your Honor, yet again, this is the witness's observation of the event, and they are just clearly recounting what events occurred.
Response, Your Honor.
Oh, yes. You may respond.
Ms. Becker is recounting what Alex Cifuentes, another witness here at this trial, said on this date. That is hearsay.
Mr. Rowe, last word.
They are not saying exactly what Alex actually said to Ms. Becker, but rather what the talk between Ms. Becker and Ms. Cifuentes was about.
I'm going to allow the statement because it does not appear it's being offered for its truth, but for its effect on the listener, Ms. Becker. So I'll allow it on that ground. Let's keep it brief, though.
Okay, would you like me to repeat that question?
Yes, please.
What did you talk to Ms. Fuentes about?
Alex started to apologize, but we've never gotten along in the past, so I just stormed off. It made me more upset.
Your Honor, I am going to ask my co-counsel to pull up what has previously been marked and admitted as Exhibit 14.
That's fine. And here it comes.
Ms. Becker, do you recognize any of these text messages?
No.
And did you send any of these text messages?
No, absolutely not.
Co-counsel, that's all for this exhibit. So, Ms. Becker, how do you know Ms. Cifuentes?
We were on the same mock trial team.
And were you and Ms. Cifuentes familiar beyond that?
No, absolutely not. We were just teammates.
From what you know, did Ms. Cifuentes have any other friends?
Yes, they were friends with Blair.
Objection, Your Honor. Speculation.
Mr. Rowe?
My witness is not speculating, but is testifying to their knowledge if Ms. Cifuentes had any other friends.
Response, Your Honor. Yes. Ms. Becker is only teammates with Alex Cifuentes. Ms. Becker herself has admitted that she didn't consider them close, so she cannot possibly know the ins and outs of Ms. Cifuentes' life.
Mr. Rowe, if you rephrase the question as to what Ms. Becker may have observed as far as a relationship, I'll allow that question, but not just globally whether she was friends with anyone else. I'll allow you to rephrase.
Thank you, Your Honor. So, Ms. Becker, from what you observed, were there any friendships or relationships with Alex Cifuentes and another person that you saw?
Yes. I know that they were friends with Blair Rollins.
And who is Blair Rollins?
Objection, Your Honor, relevance.
Mr. Rowe, you need to establish some foundation for why she thinks they were friends. What did she observe? Did they talk? Did they, hug each other? Where's this relationship going? And then you may continue with the testimony.
Thank you, Your Honor. So, Ms. Becker, retracing our steps a little bit, did you observe any signs of a relationship between Cifuentes and Rollins?
I don't remember, but I do know that they were friends. Everyone kind of knew that they were friends, so that's.
Did you ever observe them talking to each other?
Yeah, probably. I don't have like a specific instance, but.
So you have seen them talking?
Yes.
Okay, so who is Blair Rollins?
Blair Rollins is another student at CHS.
Have you ever seen Blair Rollins?
Yes, I have.
And have you noticed anything in common between you and Rollins?
Yes, we look similar physically, and people confuse the two of us a lot.
Are you aware of Rollins' father, Jonathan Rollins, and a case he was involved in?
Yes, in the community, Mackenzie Brackman, who's now dead, represented him in a case, and they lost.
Objection, Your Honor, speculation.
Mr. Rowe?
Your Honor, this is how this case is known in the community, so it is a well-known fact to Ms. Becker and other members in that community. So Ms. Becker can testify.
Ms. Frau?
Ms. Becker is not in any way an expert on whatever trial happened on whatever trial Mr. Rollins was involved in. I don't think she's qualified to speak on it without speculating.
All right,
Your Honor, may I respond?
I understand the argument. I'm going to allow Ms. Becker to testify to this. So far, there is no speculation, merely her knowledge of what has been known in the community. There is no opinion yet that's been offered, so let's continue. There may be an opinion, but not yet, so let's go.
Ms. Becker, in the community, how are you aware of Jonathan Rollins?
In the community, Jonathan Rollins was sent to jail, and Mackenzie Brackman was the one that lost the case that sent Rollins to jail.
Is there any relationship between Jonathan Rollins and Blair Rollins?
Yes, Jonathan Rollins is the father of Blair Rollins.
Thank you. Let's move on to the day Brackman was found deceased. On that morning, what did you wake up to find, or rather not find?
I couldn't find my phone. Me and Taylor cut classes that day so that we could find it.
And what efforts did you take to find your phone while retracing your steps?
We went to the mall and the Fry Shack, and Taylor kept calling and texting my phone, but it went straight to voicemail, so we never found the phone.
Did you ever stray from your search for your phone that day?
No, we just kept on retracing our steps.
On the afternoon of March 6, 2020, did you ever go by Mackenzie Brackman's house?
No, we were only checking around the mall, the Fry Shack, and our own houses. I didn't even know where Brackman lives.
And did you kill Mackenzie Brackman?
No, I hated Brackman, but I would never kill anyone, especially not my coach.
No further questions, Your Honor.
I will pause a moment before cross-exam. And Ms. Frau, you may cross-examine the defendant.
Yes, Your Honor. Good afternoon, Ms. Becker. Let's begin with your relationship with the victim. It wasn't a positive one, yes?
Yeah, we didn't get along.
Isn't it true that he demoted you to B team just a short while before the regional tournament?
Yes.
After you had been on the team for 4 years.
Yeah, it was really unfair.
And even though you were, in your own words, one of the best on the team.
Yeah.
Isn't it also true that after the regional tournament, he berated you in front of all of your peers, despite
Yes.
having won awards at this tournament?
Yeah.
Humiliating you?
Yeah.
This made you angry, yes?
Yeah.
So angry that you stormed out of practice and vandalized Mr. Brackman's car.
Yeah, I didn't think it would leave permanent harm, but it did, and I regret it.
But nonetheless, you wanted to show him how you felt.
Objection, argumentative question.
Ms. Frau?
Yes, Your Honor, this wording is directly from the witness's witness statement. She wanted to show him how she felt.
All right, notwithstanding that it might be in the statement, it can still be argumentative, but I don't consider that argumentative. It's merely stating in a matter of intent, not argumentative. So objection for argumentative is overruled. You may proceed.
Ms. Becker, you wanted to show him how you felt.
Yes, I did.
So, in a moment of anger, your judgment was clouded and you vandalized his personal property.
Yeah, and I regret it a lot. I would go back and do everything differently if I had the chance.
And in response, Mr. Brackman kicked you off of the team.
Yes.
And even after you tried to apologize, even offering to pay for the damage, he wouldn't let you back on the team.
Yes.
So after all of that, wouldn't you say that you hated Mr. Brackman?
Yes, but not enough to kill him.
But in clarification, you hated Mr. Brackman.
Yes.
Objection, asked and answered.
Because the witness qualified her answer, it is appropriate for counsel to re-ask overruled. You may proceed.
No further questions, Your Honor.
We'll pause a minute before redirect. Pause a few seconds before redirect, I should say. And Mr. Rowe, you may redirect your client.
Ms. Becker, excuse me, let me restart. Ms. Becker, what did you think you wrote the message on the car with?
I thought it was dry erase marker. I would never leave permanent harm intentionally.
And did you have any intent to ruin the car?
No, absolutely not.
After your fit of rage, did you talk to anyone about this?
I talked to my mom, and Taylor Perkins, but no one else.
And how did the conversation with your mom go?
I told her that that I'd do anything to get back at Brackman, but that was never, that was a baseless threat. It was never going to amount to murder.
And did your mom react to this in any way?
Yeah, she calmed me down and she made me think more rationally and to see beyond my anger.
And then you attempted to apologize?
Yeah, several times.
Finally, did you kill Mackenzie Brackman?
No, absolutely not. I would never kill anyone.
No further questions.
And we'll pause a moment before recross. And Ms. Frau, any recross, I'm sorry?
Yes, Your Honor. Ms. Becker, upon describing the instance with Mr. Brackman's car to your mother, how did you describe it?
I was angry and I told her that I would get back at him at any way that I could, but that was my irrational, that was spoken out of anger. It wasn't what I was actually planning to do.
You told your mother that Mr. Brackman kicked you off of the team.
Correct.
Did you tell her why?
No.
You didn't tell her that you had vandalized Mr. Brackman's car.
No, I was really ashamed.
You told her that he had done it for no reason.
Yes.
No further questions, Your Honor.
Thank you. And Ms. Becker, you are excused. You may return to council table. And we will pause just a moment before we have the second witness for the defense. And I just paused between witnesses as I indicated to let the scoring jurors catch up on their scoring. And Ms. Bellani, if you would call your next witness, please.
Thank you. Your Honor, I would like to call witness Taylor Perkins to the stand.
And for our next witness, if you could give both your character name and your student name, actual name, please.
Of course. I'm playing Taylor Perkins, and I'm also Lily McGee.
Thank you. And I will assume, Ms. Perkins, that you have taken the stand. If you'd please raise your right hand. Do you solemnly swear or affirm under penalty of law that the testimony you're about to provide today in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
And Ms. Bellani, you may proceed.
Thank you, Your Honor. Ms. Perkins, please state your first name and spell your last for the record.
Taylor Perkins, Perkins.
Thank you. So tell us a little bit about yourself. Where do you attend school?
I am a freshman at Colorado University Boulder, and I graduated from Colorado High School last year.
So at Colorado High School, what extracurricular activities, if any, were you a part of?
I did mock trial, but only because my best friend did it.
Who is your best friend?
Avery Becker.
How did you know Miss Becker?
She was also a CHS student and did mock trial with me.
How did you and Miss Becker perform at mock trial?
I was okay, but Becker was amazing without even putting much effort into it, which upset Brackman.
Who's Brackman?
Our late team coach and litigator.
Since Avery did not put in much effort to mock trial, did you notice that she came unprepared to meetings often?
Yeah, sometimes. And there was this one day where it got really bad.
What occurred during that meeting?
Avery showed up the most unprepared that I've ever seen her, and Brackman got really heated and demoted her to B team.
How did you react to Miss Becker's demotion to the B team?
I decided to step down in support of her.
Why did you decide to step down?
I knew that if I stepped down, Brackman would have no other choice but to replace me with an experienced member like Avery.
Do you regret this decision at all?
No.
And after you decided to step down, did the team's performance change at all?
They did really well at regionals, but unfortunately, Avery got kicked off the team before state.
Why did Miss Becker get kicked off the team?
She unknowingly vandalized Brackman's car with a permanent marker.
You say that she vandalized the car unknowingly. What do you mean by this?
It was meant to be done with—
Your Honor, speculation.
And Ms. Bellani?
Your Honor, my witness is simply making an observation about how she recollects the events.
Ms. Fitzsimmons?
Your Honor, as Ms. Perkins was not on the team at this time, she did not attend this practice, and she cannot speak to Ms. Becker's intention when Ms. Becker was writing on the car.
The question, though, was, would you state the question again? I don't think that addresses the question.
Yes, Your Honor. I asked that Ms. Perkins stated that Avery unknowingly vandalized the car. I asked what she meant by this.
The knowledge issue. if you can lay a foundation for whether Ms. Perkins has personal knowledge as to the issue of whether this was a permanent marker or a dry erase marker. I'll allow that question.
Sure, Your Honor. Miss Perkins, did you know if Avery used a dry erase marker or a permanent marker on the car?
It was Avery who told me what her intentions were right after the incident.
Understood. So, did she vandalize the car with a permanent marker or a dry erase?
It was done with a permanent marker on accident.
But she meant to use a dry erase marker.
Yeah, that's
Objection,
correct.
Your Honor. Leading question.
As a follow-up to the previous answer, I'll allow that. It is perhaps leading, but in the context of the stream of the questions, I'll allow it. You may proceed.
Thank you, Your Honor. So you said that Avery got kicked off the team after this incident, and why?
Yes, because of the incident with Brackman's car.
What happened after that?
She contacted the entire mock trial team and even Brackman to figure out a way to get back on the team. She even showed up on practice to apologize to him in person, but he kicked her out.
So Avery did try to apologize both in person and over text to Coach Brackman.
Objection, Your Honor. Leading question.
It's a summary of the two previous questions and the answers. I'll allow it as a summary. Let's proceed.
Ms. Perkins, would you like me to repeat the question?
Yes, please.
So, just to summarize, Avery did try to apologize both over text and in person to Coach Brackman.
Yes, that's correct.
Okay. So let's talk about Thursday, March 5th, the day that Avery got kicked out of practice. What happened after she left?
She came over to my house and we just hung out.
Were you and Miss Becker at your house for the entire evening?
No, we actually left for the Fry Shack later.
Was there anyone else that you knew at the Fry Shack?
We should have expected it, but the rest of the mock trial team, including Alex Cifuentes, were there.
Who is Alex Cifuentes?
He was another student at CHS and a mock trial team member.
How would you describe the relationship between you and Alex?
Alex has always come across as insincere and passive aggressive.
And how would you describe the relationship between Alex and Miss Becker?
Objection, Your Honor. Speculation.
You'll need to lay a foundation as to what her knowledge, if any, would be based on. Observation or anything else.
Yes, Your Honor. So, Miss Perkins, you were on the mock trial team with Alex, correct?
Correct.
And you were also on the mock trial team with Avery?
Yes.
So, were you able to observe the interactions between Alex and Miss Becker?
Yeah, Alex actually, he acted like a typically jealous person towards Avery.
Would you say that the relationship between Miss Cifuentes and Miss Becker was a good one?
No.
Speaking of other CHS students, do you know a student named Blair Rollins?
Yeah, Blair. If you asked anyone in our high school who would most likely grow up to be a serial killer, they'd answer Blair. Didn't help that Brackman lost the case that sent her dad to prison.
What else happened while you were at the Fry Shack with the other mock trial members?
Alex came over to talk with Avery and I at our table, and Avery got upset and stormed the bathroom. What
happened when Miss Becker stormed off to the bathroom?
She actually left her phone on the table, which was pretty surprising considering that like a third kidney to her.
When did you and Miss Becker decide to leave the Fry Shack?
As soon as Avery came back from the bathroom. We were done talking to Alex, so we left.
You mentioned that Miss Becker left her phone on the table before she went to the bathroom. Do you remember if she brought it with her when you left the restaurant?
I was not 100% sure.
After you left the Fry Shack, what did you and Miss Becker do for the rest of the night?
We just walked around the mall.
Okay, let's move on to the day of the crime. What occurred the next morning on March 6th?
Avery came to pick me up for school, and I asked her about why she wasn't answering my texts or calls. And that's when we realized that her phone was lost.
How did you and Miss Becker react to this realization?
Avery was super concerned, so I suggested we just skip school.
Okay. Where did you and Miss Becker decide to go to retrace your steps?
We went to all the stores in the mall that we had visited the day before, and then we went to the Fry Shack as soon as we remembered that she could have left it on the table. It wasn't there either.
Did you try to use any other technology or phones to try to find Avery's phone?
Yeah, we actually used my phone to try and call hers, but no, nothing.
When did you decide to stop searching for the phone?
Once we were back at the Fry Shack and hadn't gotten word of it, we gave up.
Now, when you went back to the Fry Shack in the afternoon, was anyone else that you knew there?
Yeah, actually, the mock trial team and Alex were there.
Did you think that this was weird?
It was. They were supposed to be at practice.
Do you know why they weren't at practice?
Unfortunately, now we do know that that was the time Brackman was tragically killed.
Throughout the course of this day, did you and Miss Becker ever stray from your search for the phone?
No, never.
And did you go to Mackenzie Brackman's house?
No, not at all.
And you were with Miss Becker all day?
The whole day, yep.
And over the course of the days leading up to the murder, as well as the day of the murder, did you ever observe Miss Becker acting unusual or angry?
Oh, no.
Why are you testifying here today?
To tell the truth.
Finally, because you and Avery are so close, would you ever lie to support her?
No, not when it concerns someone's life.
No further questions, Your Honor.
We'll pause a moment before we have cross-exam. And Ms. Fitzsimmons, you may cross-examine Ms. Perkins.
Thank you. Good morning, Ms. Perkins. Let's start with your relationship with the defendant, Ms. Avery Becker. You and Ms. Becker were close?
Yes, the best of friends.
And you worked together a lot in mock trial, correct?
Yeah, we did.
And you were also friends outside of mock trial?
Yes.
And in your opinion, Ms. Becker was very good at mock trial?
Yeah, she was the best lawyer on the team.
But your coach, the victim, Mr. Brackman, had what you described as a feud with the defendant?
Yeah.
And Avery often played pranks on Mr. Brackman?
Yeah.
And so he often got very angry with Avery?
Yes.
And this was because Avery was always unprepared?
Not like she needed to be prepared, but yes.
So Avery was demoted to the B team?
Unfortunately and unfairly.
And you felt bad, so you decided to quit mock trial so Avery could have your spot?
Correct.
And then Avery went to regionals and won 2 awards?
Yes, she did.
But Mr. Brackman was still angry with Avery?
Yeah, he was.
And you heard about Brackman and Miss Becker's fight at practice?
Yeah, I did.
Where Mr. Brackman said that Avery didn't deserve the awards?
Yes, I know. He did say that.
And this made Avery upset?
Yeah, I was a little upset myself.
So Avery irrationally vandalized Mr. Brackman's car?
It was a moment of impulsivity, yes.
And she wrote Worst Attorney Award in permanent marker.
Yeah, unfortunately.
And Brackman kicked Avery off the team for good.
Yeah.
But Avery tried to get back on the team.
Oh, yes, several times. Apologized in person, got the mock trials help.
Yeah, so would you say she made every possible effort?
Yeah, I would say so.
She even asked Alex Cifuentes for help?
Yeah, was a last resort, but yes.
And she went to a practice.
Yeah, she did.
The night before Brackman's murder?
Is that a question?
Yes, sorry. The
And
practice you went to was the night before Brackman's murder?
Yes, correct.
And Brackman did not let her on the team at this practice.
No, he wouldn't accept her apology.
He kicked her out of practice?
Yeah, he did.
And Avery felt this was unfair?
Objection.
It was unfair.
Extrapolation.
Ms. Fitzsimmons. Not whether Ms. Perkins felt it was unfair, but that the defendant felt it was unfair.
Yes, may I rephrase the question?
Yes, you may.
Did Avery indicate to you that she thought this was unfair?
Yeah, I also thought it was unfair.
So Avery usually drove you to school, correct?
Yeah, sometimes I drove her.
And you called her multiple times on the morning of March 6th to see if she was coming?
Yeah, and I even texted her too. No answer.
Yeah, she didn't answer. And so she didn't end up driving you to school that day?
Oh, no, she did.
But you and Avery both skipped school on March 6th, 2020, correct?
Yeah, to look for her missing phone.
And this was the day of Mr. Brackman's murder?
Yeah.
No further questions, Your Honor.
We'll pause a moment before redirect. And Ms. Bolani, you may redirect your witness.
Thank you, Your Honor. Miss Perkins, even though you and Miss Perkins are Miss Becker are best friends, would you ever lie to support her in this case?
Never, no.
And just to clarify, you only participated in mock trial because Miss Becker did?
Yeah.
And did you go to Mackenzie Brackman's house on March 6th?
No.
And you were with Avery Becker the entire day of March 6th?
The entire day, yes.
Including the time of the murder?
Yes.
No further questions, Your Honor.
I will pause a moment before recross. And Ms. Fitzsimmons, recross if any.
No recross, Your Honor.
Thank you. And Ms. Perkins, you are excused. Thank you very much. And we'll pause just a moment to let our scorekeepers catch up before the third and final witness for the defense. And Ms. Sorbala, I'm sorry, that's for the prosecution, I'm sorry. Mr. Cuniff, for the defense, if we could have your next witness.
Yes, Your Honor. The defense counsel would like to call Blake Van Owen to the stand.
And Mr. Van Owen, I'll assume you're on the stand. If you could give your name and your student actual name as well.
My name is Blake Van Owen. I am being played by Dylan Zook.
Thank you. And Mr. Van Owen, if you could raise your right hand, and you may leave your microphone on. Do you solemnly swear or affirm under penalty of law that the testimony you're about to provide today in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
And Mr. Kunith, you may proceed.
Thank you, Your Honor. Good morning, Mr. Van Owen. Can you please state and spell your last name for the record?
My name is Blake Van Owen, Vanowen.
And what do you do for a living?
I'm a private investigator, professor, and what is it? And a crime scene reconstructor.
And what did you do before all of this?
I worked in the Aurora Police Department as a school resource officer and private security guard.
Now, what type of education do you have?
I obtained my master's degree in criminal justice through Ashford University and taught at the Community College of Community College of the Rockies and CU Denver.
As an expert witness, what areas do you specialize in?
I testify regularly as an expert witness in areas of police work and crime scene reconstruction and cell phone tower analysis, along with general police investigation tactics.
Where have you been accepted as an expert witness?
I've been accepted as a defense expert in the U.S. District Courts and state courts in multiple states, which I have been accepted as an expert witness in multiple fields, multiple times.
What does being an expert witness entail?
Say again?
What does being a defense expert witness entail?
Prosecutors use law enforcement personnel for their expert witnesses. I specialize in all areas that law enforcement personnel specialize from experience.
Your Honor, I would like to offer Blake Van Owen as an expert in crime scene reconstruction, cell phone tower analysis, and general police investigation tactics.
And Ms. Fendrich, any objection to any of those areas?
No objection, Your Honor.
Then I will qualify Mr. Van Owen in areas of police crime scene investigation, cell phone analysis, and general police procedures. You may proceed, Mr. Kunith.
Thank you, Your Honor. Now, Mr. Van Owen, what have you investigated in this case?
Reviewed and analyzed the police reports by Kyle Kuzak and Detective Markowitz.
In your expert opinion, what is your conclusion on the investigation?
The police investigation was rushed and there were missing pieces.
What were these missing pieces?
There's inconsistencies with the investigation, the physical evidence of the struggle, the weapon, the theory that Brackman was surprised by a ring notification, and the photos of blood is missing.
Now, moving on to the crime scene investigation, or crime scene reconstruction, rather, conducted by Mr. Kyle Kuzak. Did you disagree with anything in regards to that?
No.
In terms of that, did you find any bias?
I did, yes.
And is it possible that Cusack could have been biased by someone?
Yes. It's possible that Markowitz planted the idea of Avery Becker being a suspect in Kuzak's mind before Kuzak analyzed the crime scene.
Objection, Your Honor. Improper character evidence.
Mr. Kunith.
Your Honor, in terms of Mr. Van Owen explaining these sources of bias, this is located within the witness statement, and he has a full right to testify in regards to these matters, as well as his expertise.
And Ms. Fendrich?
Your Honor, the opposing counsel is asking for their witness to make assumptions about the way that the prosecution handled the case based on characteristics and aspects of their personalities, as opposed to actual evidence from other incidents and so on and so forth. So I don't see how they could be qualified to make that sort of assumption about another person.
Your Honor, may I respond briefly?
Yes, you may.
In terms of speculation, as I stated earlier, Mr. Van Owen is absolutely qualified to speculate upon these matters based off the evidence he has received and based off of the material that he has investigated.
All right, the objection, though, is based on 404B character evidence. I don't see that there has been a, although disputing the credibility of another witness based on bias may be about their character, it is actually a separate issue. And the credibility on bias, if Mr. Van Owen feels that another witness has been biased in the testimony, that is not technically 404B character evidence. They may challenge the credibility of another witness. So overruled, you may proceed, Mr. Kuneth.
Thank you, Your Honor. Now, moving on, I'd like to move on to the physical evidence of the struggle. What was inaccurate with it?
The only evidence of a supposed struggle is the scuffing of the floor. However, there, with no before or after picture, these scuffs could have been made before or after the murder.
And is there any way to date these scuff marks?
No.
Now, in terms of the murder weapon, what was inaccurate with that?
In Kuzak's investigation, they came to a conclusion that the intruder stabbed Brackman with the same knife in the kitchen, but no proof the knife was from Brackman's kitchen.
Now, moving on, there's also the mention of ring notifications in terms of that. Was there anything missing?
The only thing missing would have to be the notification on Brackman's phone.
And finally, touching off last briefly, in terms of any photos taken, were there any photos missing?
Photos of the blood.
And what could have the police department done differently?
They could have kept multiple copies. They could have archived them.
No further questions, Your Honor.
I will pause just a minute before cross. And if there is a time check for cross-examination. Plenty of time, thank you. And Ms. Fendrich, if you will proceed with your cross-examination of Mr. Van Owen.
Good morning, Professor Van Owen. Let's begin by discussing your relationship with the police. So you used to work for the Aurora Police Department, correct?
Correct.
But you left your job after an altercation that made you reassess your trust in law enforcement, is that right?
Objection to relevance, Your
Honor. Ms. Fendrich.
Your Honor, I'm merely laying the foundation for more questions that will come later regarding certain biases that this witness may hold.
Your Honor, may I respond?
Yes, you may.
It appears that the attorney here is questioning upon the qualifications of Mr. Van Owen, upon which we have already qualified him as an expert witness.
And Ms. Fendrich?
It is up to the jury's discretion to decide how much they choose to believe of this witness's testimony. I'm merely here to lay out the facts.
I'm going to permit the questions and overrule the objection, although the witness, as I indicated, is has been qualified without objection. The credibility of the witness may also turn on what their credentials are. So that he may still offer his opinion, but credibility is always a jury question. So objection is overruled. Ms. Fendrich, you may proceed.
I'll restate my question. So you left this job after an altercation that made you reassess your trust in law enforcement, is that right?
Yes.
Would you consider it your duty to keep police officers in check?
Yes.
So you could say, in other words, that you have an unfavorable view of them?
Yes.
Now, you've worked with Detective Markowitz before, is that right?
Correct.
And you consider them to be good at their job?
Yes, I do.
Do you think Kyle Kuzak is good at their job?
Yes,
Do you believe that if you'd handled the case, it would have been more accurate?
yes. If they did a better investigation and didn't rush it, their investigation would have been better and more conclusive.
Do you think that if the defendant were to be acquitted, it would reflect poorly on Detective Markowitz and Kyle Kuzak?
Yes,
Now, considering your business, you charge quite a bit for your services, $6,000 to $10,000, if I remember correctly.
correct.
And a good portion of your expertise revolves around revealing the alleged failures of the police.
Yes,
So you could say that your success relies on the alleged negligence of law enforcement.
yes,
Moving on, you only ever testify specifically as a defense expert, is that right?
that is correct.
Objection relevance.
Overruled. We've already addressed that issue. He admitted that he was worked for the defense. That may be part of his credibility. Overruled.
I'll restate the question. You only ever testify specifically as a defense expert, is that right?
That is correct.
And just for clarification, this is the side that the police oppose.
Yes,
So you could say that since your resignation from the Aurora Police Department, you consistently worked against police efforts.
this is true.
No further questions, Your Honor.
And we'll pause a moment. Could we have a time check on redirect for Mr. Kunith? Good enough. Mr. Kunith, redirect.
Thank you, Your Honor. Mr. Van Owen, I have one final question. Based off all the evidence and everything that you have investigated within this case, was there any possible reason to say that there were flaws within this investigation?
There were definitely flaws.
And is it possible to say that the police could have done better?
It is.
No further questions, Your Honor.
Thank you. And pausing just a moment before recross. And Ms. Fendrich, you may recross the witness.
Thank you, Your Honor. Now, Professor Van Owen, it's been a long time that you've been working as a defense expert, is that correct?
Yes, I have.
So would you say that you've ever testified on the prosecution side as an expert witness?
No.
Objection, Your Honor. This is outside the scope of my redirect.
I agree. Ms. Fendrich, let's direct it towards redirect.
Yes, Your Honor. Have you ever testified on behalf of the prosecution?
No.
That is all. No further questions. Thank you, Your Honor.
Thank you. And Professor Van Owen, you are excused. Do we have any additional witnesses for the defense from lead counsel?
No, Your Honor, the defense counsel would like to rest its case.
Thank you very much. We'll pause just a moment before we have closing arguments. And who will be doing closing for the prosecution?
I will be conducting the closing.
Thank you. And for the defense?
I, Braden Rowe, will be conducting the closing.
Mr. Rowe, thank you. And we'll proceed in just a moment while the scoring jury has a little time to do their work. Do you wish on the prosecution side, Ms. Fitzsimmons, to reserve any time in advance for your rebuttal?
Yes, please.
And how much time, just so the timekeeper knows to give you notice?
May I do my whole closing and then just see how much time is left?
You may do it any way you wish, absolutely. And we will now have closing. Ms. Fitzsimmons, closing for the prosecution.
Thank you. The death of a beloved coach, betrayal, a scandal that shocked a school to its core. The defendant has been accused of attempting to seek revenge on their mock trial coach, Mackenzie Brackman, by way of burglary and inadvertently murder. They faced the charges of murder in the first degree and second-degree burglary. Today, the prosecution called 3 witnesses that built a clear case against the defendant. First, you heard from homicide detective Jordan Markowitz, who testified to her conclusion that the defendant is in fact guilty after conducting a thorough investigation into the case. From her, you heard about how the burglary took place in the early afternoon of Friday, March 6th, when the victim usually would not have been home. Detective Markowitz also highlighted the incriminating cell phone data, which showed the defendant's phone travel from their house into the victim's residence around 1 in the afternoon that day. Next, Ms. Kyle Kuzak, a crime scene reconstruction investigator with over 19 years of experience, was called on to detail the events that took place at the victim's residence on Friday, March 6th. Using the evidence in this case, Ms. Kuzak described to you how the perpetrator approached the victim's residence from the front door, alerting the ring security system, and then promptly snuck through the side gate and around back. The victim, having been alerted to the intruder's presence via 3 different security sensors around his residence, armed himself with a chef's knife from either the knife block or an open knife drawer found in his kitchen. Ms. Kuzak testified that all the evidence in this case points to a planned burglary gone wrong, where the intruder entered the house early Friday afternoon and was shocked to find the victim at home armed with a knife. The resulting struggle between the defendant and victim left beloved mock trial coach Mackenzie Brackman dead. Finally, you heard from the defendant's close friend from the mock trial team, Alex Cifuentes, who testified to the defendant's history of irrational behavior and anger towards Mr. Brackman. Ms. Cifuentes described how the defendant had previously vandalized the victim's car, writing Worst Attorney Award in a permanent marker across the hood after being told off for her inappropriate behavior at the regional mock trial tournament. When this event led to the defendant's expulsion from the team, she did everything in her power to get back on. Ms. Cifuentes showed text messages sent to her by the defendant after this incident, where she describes her intention to trash the victim's residence if they are not let back on the team. Today, you also heard from the defense's 3 witnesses as they desperately tried to get the defendant acquitted for their crime. They called upon the defendant herself, who did not shy away from her anger and clear hatred toward Mr. Brackman, even today, on trial for his murder. Acting irrationally is what Ms. Becker does best. We saw it when she vandalized Brackman's car, and then later when she told her mom that she would, quote, get back at Brackman if it was the last thing she did. When the defendant was kicked out of practice on March 5th, 2020, her anger continued to build up. And Ms. Becker acted irrationally again on March 6th, 2020, when she skipped school, went to Mr. Brackman's house to trash it, and again when she killed him. And next, the defense called on Taylor Perkins, the defendant's best friend. Ms. Perkins has demonstrated her clear loyalty towards the defendant in the past, going so far as to drop out of mock trial so that the defendant could take her spot. Ms. Perkins testified that the night before Mr. Brackman's murder, the defendant had gone to a practice in a last-effort attempt to get on the team, but was unsuccessful. Ms. Perkins also highlighted the hatred in between the defendant and Mr. Brackman and the defendant's tendency to play pranks against him, such as vandalizing his car. And finally, you heard from the private investigator that the defendant hired, Professor Blake Van Owen. He attempted to reconstruct the crime scene using police reports and Ms. Kuzak's own reconstruction, and came to a conclusion based more on his desired outcome than the facts and evidence shown in this case. His investigation wasn't just missing pieces of the puzzle, it was ignoring the pieces that were in plain sight. As Ms. Kuzak testified, Van Owen's theory involves Brackman, a man armed with top-notch security systems all around his residence, sitting at his kitchen table, completely unaware as an intruder alerts 3 alarms, opens his back door, walks across the kitchen, and then stabs him in the back with an upside-down chef's knife and flees. It seems clear today that the evidence is abundant and all points to the defendant. The prosecution has been given the burden of proof in this case, and we have proved without a doubt that the defendant committed second-degree burglary when they entered the victim's residence with the intent to trash his house, not expecting Mackenzie Brackman to be home. But unfortunately, Mr. Brackman was home that afternoon, and so the defendant acted irrationally, and the struggle between intruder and victim cost beloved mock trial coach Mackenzie Brackman his life. Based on the evidence presented today, there is no reason that a verdict other than guilty should be returned. Thank you.
Thank you. I will pause just a moment before closing for the defense. And Mr. Rowe, you may present the closing argument for the defendant.
Thank you, Your Honor. There always seems to be a missing piece to the puzzle. The frustration knowing you didn't fully complete the puzzle is always there with these missing pieces. The puzzle is the case we are looking at today, and the prosecution, thinking they have all of the information that they need to prove the counts brought upon the defendant are true beyond a reasonable doubt. However, their case is riddled with missing pieces, and the evidence you heard today undoubtedly shows that the defendant, Avery Becker, did not commit these crimes. First off, let's review the counts. The first count is murder in the first degree, and the second count is second-degree burglary. That second count is outright, and there is no way it can be proven beyond a reasonable doubt. It's the only personal possession of Mackenzie Brackman that was broken was a plate, and that single plate was broken on accident. There are so many other missing puzzle pieces in the prosecution's case. The first missing piece is that there is no way of knowing that Avery Becker was at the victim's residence on March 6, 2020. Becker was rather out with their friend, Perkins, looking for Becker's phone, which was lost or stolen the previous day. The cell phone tower data Markowitz brought up cannot sufficiently prove Becker was at 444 South Flower Street, but rather the phone was in that general area. The second missing piece is that there is no way to tell who was at the door because the perpetrator was wearing a mask and gloves, concealing their face and preventing any DNA or fingerprints from being found. The third missing piece is that there is no way to tell who was at the door. So it could have been someone else. Blair Rollins is the person that hates Brackman more than anyone, and their father was sent to jail in a case in which Brackman lost. Blair Rollins, it might just be me, but that seems like a motive for Blair Rollins. And the fourth missing piece is that Avery Becker had a lack of motive. They are just a teenage kid attempting to be extremely apologetic and remorseful to Mackenzie Brackman for the accident at hand. The fifth missing piece is that there is no way to tell Avery Becker is friends with Alex Cifuentes, despite what prosecution wants you to think. The sixth missing piece is that Avery Becker would never go to Alex for help, so the screenshots could easily be fake, putting the blame on Avery Becker. The seventh missing piece is that there is no way to be 100% sure that Brackman was alerted by the Ring doorbell and security system and able to arm himself in 10 seconds. The knife is the eighth missing piece, as the perpetrator easily could have brought it, and there is no way to prove that it was in Mackenzie Brackman's house. The ninth missing piece is that there's no way to be sure the struggle ensued, breaking a plate and creating scuff marks, as there are other ways this can happen. The 10th missing piece, and the final, is that the prosecution was sloppy enough to lose a potentially crucial piece of evidence, the blood splatter photos. The insane thing about all of this is that nobody looked into this information. Detective Jordan Markowitz and Kyle Kuzak did not look into this, but took the easy route, rather than taking the time to gather all of the evidence they needed to surely prove it was Avery Becker, Blair Rollins, or any other suspects in this case. Rather, they jumped to the easy conclusion and only used the evidence they wanted to come out in that conclusion, and ignored all other evidence. We cannot believe the biased, sloppy prosecution who were not able to handle the collection of evidence, keeping of evidence, and analysis of evidence. Missing, missing, missing. The prosecution is simply disregarding these missing pieces, the most prominent ones being the lack of direct evidence and witnesses, specifically eyewitnesses, to prove beyond a reasonable doubt that Avery Becker committed these counts. They are also saying the puzzle looks complete and awesome without these pieces, while it is unrecognizable. There is no way a prosecution can prove beyond a reasonable doubt that Avery Becker committed these counts brought upon them. If beyond a reasonable doubt was way above my head, they can't even get up to my waist with evidence to prove. And that is why I ask of you to submit a verdict of Avery Becker being not guilty in this case.
Thank you. And before we have the prosecution's rebuttal, could we have a time check on rebuttal time? Ms. Fitzsimmons, that's up to you.
No rebuttal, Your Honor.
Thank you. All right, the case is concluded. Thank you very much, all of you. When the deliberating jurors have submitted their score sheets, please activate your video and your microphones. That way I'll know that you're all set to go and we can have some comments. In the meantime, I will make a few comments before I see Mr. Henderson, Mr. Bird, and Mr. Rich come on the screen. You're probably a lot more comfortable than you were yesterday. This is uncomfortable for everybody. It's uncomfortable for me. And I've done a number, before I retired 5 weeks ago, I had done a number of court trials, but in the last 11 months, I'd only done one jury trial. That was in person. We opened up and closed down the courthouse just before and just after that. So doing a virtual jury trial is just very strange. So don't feel badly that you felt uncomfortable. As I said, you're probably much more comfortable than you were yesterday. We'll try to keep our comments brief so that you can get some lunch and we can move quickly towards the next round. Mr. Henderson, any comments you'd like to make?
Sure, thank you, Judge. And thank you, and excellent job to all of the students. Can really tell that you're continuing to refine your game from what I saw yesterday, which was already at a high level. So a really excellent job. And I do want to commend both teams for your exceptional professionalism. Really excellent jobs, not sniping at each other. Nothing gets on a judge's nerves more, or really even, I suspect, a jury's nerves more than lawyers and sides who snipe at each other. So a really excellent job. A couple of other points. Ms. Fendrich, really an excellent job dealing with the connectivity issues. One of the jobs of a trial lawyer is to be nimble and deal with the situations, the hand that you're dealt. So excellent job with that. Ms. Frau, really loved your style on direct examination. It was very relaxed and very genuine, even in spite of this rather stilted environment that we're dealing with here through Zoom. Ms. Fitzsimmons, excellent leading questions on your cross-examination. They're really tight and left your witness no wiggle room. Mr. Kunith, excellent job on dealing with the connectivity issues and still pressing on with your really good cross-examination. Mr. Rowe, a really good job on the cross involving the knife. That was my cryptic note to myself. And Ms. Villani, you really did a marvelous job as well with your cross-examinations. A couple of more generalized statements. For the openings and the closings, I'd love it if you could slow down, relax a little bit. And I know you're trying to cram an awful lot of information into a short period of time, but at some point as a juror, it becomes information overload. It's coming at you so fast that you can't absorb it all. So slow down, have some pauses. And I think there is some reading going on, and that tends to keep you at a constant pace rather than altering your pace. Pausing. And so think about that. There are a couple of instances where your witness gave you what I would call gifts when you are engaging in cross-examination. There was one gift where Ms. Cifuentes said, "I should have won it." Well, that right there, rather than going on to the next question, seize upon that. So you're saying you should have won that award? And repeat that back to the jury that as a lead into your next question, because that was all about bias at that point and motive. So play upon that. There was one other reference to, it was unfair, said, or it was really unfair, came out during the cross of Becker. So again, play on that. Yeah, it was really unfair, wasn't it? It was so unfair that you then grabbed the marker and ran outside and, scribbled, but use their own words back against them. And that's one of the most highly developed skills of an excellent trial lawyer, is to listen and use that again in your ensuing questions. One last thing is burden of proof. Make sure that you talk about the burden of proof, particularly on the defense side, to point out how the prosecution's burden of proof is beyond a reasonable doubt. And let's tick through the elements and let's hit on the ones that they failed to prove beyond a reasonable doubt. Prosecution, it's not beyond all doubt. It's just reasonable doubt. What doubt's reasonable? So make sure that you touch on those. In closing, for my remarks, I just want to say really, really excellent work. And I'm so pleased. I consider my time very well spent here listening to your excellent work. So thank you.
Mr. Byrd?
Oh man, I got to follow that up. I think you guys did a wonderful job. I did take some notes here, but a lot of them are going to be repeats. So I agree with the slowing down, but I do understand that you're trying to get a lot of information in. And the reading makes it seem like it's less natural, and that I think led to the going quickly, where you're not taking those natural pauses and it sounds like it's organic. But again, I understand that you had a lot that you tried to get in 5 minutes or even after the opening, but especially in the opening, that's when I first noticed that you're just flying through it, and the closing was similar as well. Yeah, and again, to the reading, it's really important that you read as little as possible. I completely understand where you're going to want to check your notes every once in a while, especially on like transitions to a next topic, and that can even be effective. But there's two really obvious tells that you're reading. One is the eye scanning across the screen, and the second is when you ask the witness something, and then as soon as they start speaking, you look away, and you're looking, and then when they're done, you look back and you ask, and as soon as they start speaking, you look away again. And it shows that to me, it makes me think that you're going with a script rather than actually listening to your witness and acting upon what they say. I think we can get rid of the tags where we say, isn't that true? Isn't that correct? Right? You don't have to say those things, and there might be a little bit of silence, but that's perfectly fine. And along with that, when you get the response from the witness, you don't need to say, okay, or all right. You can just let it stand and then go to your next question. Silence is golden, although it can feel awkward when everyone's eyes are on you. But I wanted to talk to speak to Mr. Kunith and the way that he reacted to the technical difficulties. I think everybody did a great job with the technical difficulties, but you were especially good in being extremely professional and respectful. And I think you even tried to help, like you suggested something about the chat, if I remember correctly. That's amazing. What you need to do that so that it comes across that you're trying to win on the merits. You don't want to win on technicalities and technical difficulties. You want to win because you have the case, you know the case, and you're going to convince us that you're right. So that really, I thought was an excellent display of professionalism. And finally, I actually really, really liked the objections. I think there were more objections today than there were in both of the cases that I was in yesterday. The reason why I liked them so much is because I thought they were in good faith. I don't think that you were trying to trip up the opponent or, say something that you knew wasn't going to work, but you just wanted to get in their way. I think that you were really trying to make good objections, and that came across. So again, I think everybody did an excellent job, and I wish the best for you in your last round.
Mr. Rich.
Thank you. Tom said most of what I was going to say, so I'll go ahead and just hit some specific points. First, I'm going to start with my favorite performance of this round, Ms. Frau, your cross-examination. I love the tone, the pace, the way you responded to the questions and the way you asked the questions. You weren't aggressive. You weren't, that's my dog. You weren't rude. You just, yeah. And you just, okay, this is your answer. And you just went with it and you were deadly. It was great. So well done there. I enjoyed Ms. Fitzsimmons, your closing. I loved how you talked about the motivations of each of the witnesses. Right, that was really strong to me because when you're looking at the testimony, the question is, who are we going to believe? And when you talk about the different witnesses' motivations, I thought that was really strong. So I commend you on that. Mr. Rowe, I liked your closing quite a bit, but to the issue of motivations, I would stay away from attributing a negative motivation to the prosecution. I think there's a difference between attributing a motivation to a witness as opposed to the prosecution as a whole. So just be careful about that. I liked your closing, so don't take too much from that. Just be careful of the language that you use. It could potentially rub somebody the wrong way. And I think it was just because I had that in my head from the previous closing. Ms. Bellani and Ms. McGee during the direct examination. Ms. Bellani, I think you did a great job in setting up signposts. This is where what we're going to be talking about next. And then you gave summaries of the testimony. That was good for you. And then you looped those responses into your next question. It's a fantastic technique that I think everybody should use. And with Ms. McGee, you guys, the whole Rollins thing, that was one question and one answer. And it took care of it, and it was gone, and it was effective. And there wasn't even time to get any objection in on that one. So well done. For everybody, hearsay, everyone's favorite objection. And I think the judge made a good point during one of the back and forths on that. 9 times out of 10, the statement is not going to be for the truth of the matter asserted. I think it was during Ms. Shresta's testimony as Ms. Becker, where it was about what Beckman said. Well, we didn't care what Beckman said was true or not. In fact, Becker didn't believe it was true. It was more for just the effect on her. And when we're done with this, I do want the 14 comma rules, Mrs. Shrestha. If you look behind you, I see you got 14 comma rules. I want to know what each of those are. And the board shows lots of preparation, so you're certainly not like your character. Let's see. Ms. Frau, on your direct examination, lots of W words: who, what, where, when, why. Lots of those. It's very good. Lots of W words on direct examination. Let's see, on the defense, now this is something I took from yesterday and that I saw today that changed. On the opening statement, you said that yesterday, you said we will prove beyond a reasonable doubt that she's innocent. That's not your burden. Today, you didn't say that. Today, you said the prosecution will fail to meet their burden. Good adjustment. Ms. Fendrick, we will show 1, 2, 3, 4. You did that great a couple of times during your opening. You're laying out what we're going to do, what you're going to show. So that was great. One thing you did say on the opening, you said we must prove. Try we will prove. It's slightly different, but you're telling them what you're going to do, not what you have to do. And the reverse on the defense, of course, they didn't prove. So I won't take any more of your time. I think it was a really good job all around. And I'm really proud of both of you. It was very close on my scorecard.
Thank you. Because we have taken some time with some really good comments, I'll reserve old retired judge. You don't need to hear from him. So I'll let you get to lunch to your next round. Thank you very much. And congratulations for all of the folks hopefully still watching on YouTube, the coaches, the parents. Your kids, your students did a wonderful job. Thank you. And
Judge, before you let them go, can I just have a moment? I need to make sure that your scorekeepers, Judge, have submitted their scores. Folks, have you been able to submit your scores to us?
I have submitted my score.
Yeah, mine shows submitted.
Mr. Henderson?
Yep, I submitted mine.
Okay, all done.
Judge Wheeler, it's yours.
Thank you. And we will conclude the conference then. Thank you very much.
Great job, everybody.
For your time.